United Republic of the World Health Organization, because the country you think you live in will no longer have powers to govern if your country signs the World Health Organization Pandemic Preparedness Treaty. This is the document we've been discussing at length. What it does is allow the World Health Organization to have all of the power to decide when you're in a pandemic, when you are in danger of a pandemic, and how you must behave, your behaviors socially, emotionally, online, your speech. This is what they're trying to do. This was originally endorsed by Boris Johnson and President Joe Biden in 2021. And now here we are in 2023. And the WHO doesn't have a very good, in my opinion, COVID report card. But we still want to hand them global powers over nation states anyway. Now, what the update is, because we've been updating you every time they release a draft of this document, and this, as it stands, that document will be revised and gone over again in July. And then voting will start to take place in 2024 for nations that adopt a full version. So we have some time. I'm very anxious to see that final draft that comes out in July. What we have now is edits to the World Health Organization's articles of international health regulations. And the reason that they're doing this is they have to it's almost like they have to amend their underlying powers in order to give themselves more powers. So they revised this document, and it's worth taking a look at, because you can already see how this is going to go based on these edits in the first few pages. Take a look. They're saying, that how we're defining what we're doing here, they just strike the words non-binding, meaning like we're going to give these recommendations, either standing or temporary. But before we used to say that adherence to them, by nation states was non-binding. Now we're like, not interested in that. If you're in the WHO, it's binding. So let's just get that out of here.
So any flimsy language about this not being the law of the land has been removed. It's like now we're getting the full stamp.
Yes.
It's binding.
It's the WHO. Again, remember, this is not the pandemic preparedness document. This is the World Health Organization, sort of their underlying powers now based on the extra pandemic powers. I am inevitable.
Oh,
right?
Yeah.
Like now have all power. So
they are omnipotent.
Sure.
Omnipotent. That's one of my favorite words. So all powerful. That's what the world.
Yeah. Okay. Yeah. That. Yeah. And so and then does this power only kick in when we're in a pandemic? Oh, no, it does not. According to edits to this document, it kicks in whenever they feel like we should be preparing for a pandemic. You see the word prepare there, like if we think that they cross out here public health risks, they're saying all risks with a potential to impact public health. Now, I think why we need to notice this is because you see the language ratcheting up, telling us as a society, you have mental health issues. You are very anxietized. People hurt your feelings all the time. Mental health and words are hurting you and have the potential to hurt you. So we can say now, not only do we have to have some endemic disease, but we can also say that there's a potential for a public health risk. And so that gives us the power to say that there may be something at risking the potential to negatively affect public health, right? And will they respect our freedoms, right? No, they just cross that one out here in Article 3. Normally, implementation of regulations would have full respect for the dignity, human rights, and fundamental freedoms of persons. No, not interested in that. Just cross that right out. But we will say based on equity and inclusivity and coherence. Yes, please laugh at this. Thank you for laughing at that.
Who is the person that's like, let me get out my pen here, my strike-through pen. This is my special strike-through pen. All right, human rights. Let me scratch that out. Human rights. Dignity. Yes, let's scratch that out as well.
Well, fundamental freedoms is the thing that
Like the fact that they crossed off like what kind of just like hard ass bastard do you have to be to scratch out the words like full respect for the dignity, human rights, and fundamental freedoms of persons? Be like that. This will not stand. Like that's where they're planting their flag.
Yeah.
It's like Thomas Jefferson must be rolling over in his grave. He's like, that's the kind of stuff that I wrote in to the Declaration of Independence. Right.
Don't worry though, because they say that they will make regulations based on their principles of equity and inclusivity and coherence. So like maybe we'll have some gender ideology and some, token people of different colors and stuff like that, like in our board members. So we're being inclusive, but like your fundamental freedoms, we're not that interested in that.
Well, yeah, they took something that's concrete that like you can't argue with, and they made it squishy so that they can argue with it. That's what they've done. They're like, no, this is, and this, so it's like they're
Grandis, everyone.
Wiggle room.
I can't highlight you. It's gonna take the video
Clayton
down.
and I were listening
But
to
I see everyone
a
coming
podcast
in.
the other
Great
day.
risings.
I can't remember the name of this guy. And he was talking about how these like ideological Trojan horses come in with the terms like inclusivity and equity and diversity, and
ESG,
usually like
ESG.
what they mean when that happens is like we're gonna give ourselves more power. Like this for sure feels like a woke Trojan horse. Okay. Will they maintain the power of surveillance if a small country doesn't know what to do? Yes, they will. Here's Article 5 saying that, look, we're going to tell you need to have the power to survey your population. If you can't do that, developed state parties and the WHO will assist you. So like, okay, you're too small of a country, Cape Verde or whatever, don't worry because we're going to have this on lock, this surveillance thing. And what if the officials in your...
Isn't that what's already been going on, right? Haven't I showed you and told you guys about them building these fake continents? Building up continents to prepare them to be observed as countries that will have a certain ruling. Same thing they've done everywhere, mocking all of the royal lands in the Holy Land, America, taking it to the obscene places and trying to build nations from everything in America.
Government don't agree that there is a health emergency, they don't matter. Here is how that previously was written. Can we go to the next one? That says number 3, it says before the WHO would have to consult with the state party in whose territory the event is occurring. They don't have to consult anymore. They can come into your country and say, you have a pandemic. And if you don't like that and your health officials are like, no, this is not a pandemic. We all have colds or whatever. We're not going to give you no, they decide when you have a pandemic. In fact, it removes altogether the idea that any given state could push back on whether or not there is a public health emergency. See this edit, number 3, totally crossed out, saying if, the director general and the state party, they don't agree on a consensus on whether there's a pandemic or a public health threat, then this is how you mitigate that. Gone. No mitigation. The WHO is just going to tell you. Like, there's no, sorry. And what about a pandemic? What do we do then? Do we agree on therapeutics, interventions, masking, vaccines, these things?
No.
Well, no, the WHO will do that, full stop. It says the WHO will carry out an assessment of all of these things. So, any scientific counterpoint should be basically bound
We don't
and gagged
comply to the
because WHO is
NWO.
going to be doing
We don't
all the
comply
science,
to the
all of the assessments
WHO.
shall run through them.
None of these
Because
3-letter
the Bill of Melinda
crooked
Gates
agencies.
represents alone is responsible for 88% of the total amount donated from all philanthropic foundations. The WHO, 88% comes from the Bill and Melinda Gates Foundation. So now they all therapeutics, any sort of
Bill and Melinda Gates.
pharmacological
Bill
remedies
Gates.
will run through the
Who?
WHO.
Yes.
Good.
Mm-hmm.
See how this works?
They also
Bill
wanted
Gates
just
is
a few
locked
other
up, though,
things that I'm
so
not
we
going
know
to
this
show
is
you
fictitious
screenshots because I know that
act.
doesn't make for riveting TV, but I want us all to just be
His
aware
ass
of
been
it.
locked up.
They want
Been
a sourced
executionized.
ingredient list of all vaccines. They want to be able to oppose and implement any travel bans. But there is a provision that would exempt health officials from travel bans. So we've talked about before how World Health Organization employees and board members and what have you, power holders, they don't pay taxes in the states. They have sort of superpowers for
Oh,
as
do they now?
diplomats. They don't. They get special treatment in whatever state they live in. They also would be exempted from public health travel bans, public travel bans.
Oh,
They
so they're
want
the only
full
ones that could
vaccine and
travel.
full health passports for travel. This is called the PLF, the passenger locator form, and they want this to be.
If they don't cut that bull, grandest to everyone. Let's get right into the information. I wanted you guys to see that it's it's crazy. I wanted to do the build on the law and domicile, and I said, let me play this video that shows you guys how these people are trying to litigate certain things to propagate another damn fraud that we are not going to be privy to unless spiritually we are inclined to know these demonic evil beings and what they're planning to do, right? So we see it. We know we're not going to be falling for it. We know we have all the authority and the rights of the land. Let's get into this treaty on the law of domicile, guys. And I want to try to get to this Puritan document next. I'll try not to stop and speak as much, but only very important things to note. All right, let's go.
It is the purpose of the following treatise to present to the profession a general discussion of the subject of domicile in its several phases: national, T(A)Z national, and municipal. With the exception of a little book by Round, only 2 general treatises upon the subject have appeared in the English language, namely, those of Phillimore and Dicey, both works of great excellence, but not meeting the requirements of the American lawyer of the present day, the former having appeared 40 years ago, and the latter being written exclusively from the standpoint of the English law, and citing very few of the multitude of American cases. Too much praise cannot be given to the chapter on national domicile contained in Story's Conflict of Laws. It has had great influence in molding the jurisprudence of this country on this subject, and in its successive editions has gone far towards keeping the profession informed. With regard to the current of judicial decision, Dr. Wharton's chapter on domicile, in his treatise on the conflict of laws, has rendered similar service. But the general scope of both of these works necessarily rendered the discussion brief, and forbade extended forelbeface references to authorities. In view of the state of legal literature and the wide and constantly increasing application of the principle of domicile to the determination of legal questions, as well as the great multiplication of decided cases on the subject in this country, it has appeared to the writer that a general treatise on the subject, such as is now presented, might be of some service to the profession, and hence not entirely unacceptable. It cannot be too carefully kept in mind that the subject of domicile, whatever may be its application to purely municipal purposes, is a part of the jus gen-uni and is constantly applied in the field of national law, public and private, for the determination of relations which extend beyond the limits of a single state or country. It is therefore greatly to be regretted that any distinctive local jurisprudence on the subject should arise in any state or country, and thus add to the already too great want of uniformity in the adjudication of identical questions in different jurisdictions. That such result will to a certain extent naturally and almost necessarily happen is true, but to minimize its extent is manifestly in the interest of both scientific jurisprudence and practical justice. From this consideration, as well as because in many instances much light is thrown by foreign authorities upon points as yet unsettled in our jurisprudence, I have sought to discuss the law of domicile in the light of all the authorities, domestic and foreign, ancient and modern, available to me, and in view of the fact that many of the foreign authorities are practically inaccessible to a large majority of American lawyers, I have taken the liberty of quoting from them frequently and in some instances at considerable length. Some writers on domicile have included in their discussions the consideration of the domicile of corporations. This, however, is only a figurative application of the term domicile, and is in some respects misleading. Its consideration has been omitted from this treatise, which is confined exclusively to the domicile of natural persons. The various applications of the principle of domicile are so numerous, particularly in American law, that it has been found impossible to discuss them in detail and at length without either on the one hand unduly expanding this work or on the other too far sacrificing the discussion of the main subject, to wit, the nature and ascertainment of the domicile of natural persons. Some of the most important applications have, however, been briefly referred to in a single chapter under the head of the uses of domicile. M.W. Jacobs. Habrisborough, PA, Oxford, 1887. Introduction. Section Municipal Organization of the Roman World 1 Origo and Domicilium in the Roman Law 2 to 10 Origo 3. Van. Of sense of intention 100 till act mere ab 1 check what domit the British authority of 1 b 2 hodge 2 length of precedence or time 882 ETSEQ Comau law and content.
Hold on, guys. Forward now. I want you guys to hear the preface. This goes over a lot of information. Hold on a second. All right, here we go. Let's go.
Chapter L. Introduction. 1. Municipal Organization of the Roman World. We are indebted to the civil law for both the term, happy face, domicile and the legal idea which it represents. The organization and polity of the Roman world were preeminently municipal. In its early history we find Rome, itself a walled city, having an organization and institutions suitable to the requirements of municipal life, surrounded by numerous independent states, composed in their turn either of single cities or confederations of cities. As these fell one by one under the sway of their ambitious and insatiate neighbor, either by treaty or conquest, they experienced treatment differing according to circumstances. Some, becoming allies, merely or mainly recognized the military hegemony of Rome, and retained, at least for a time, their independence in other or most other respects. Some, upon being beaten in war, were allowed to a large degree their autonomy, retaining in some cases their ancient constitutions and the power to choose their own magistrates, etc., and enact their own laws, while in other cases new bodies of laws were imposed, or the power of selecting magistrates was denied, etc. Again, some of the conquered cities were depopulated in whole or in part, and had introduced into them colonies, bringing with them new constitutions modeled usually after that of Rome itself. One Seekizoist, of civilization in system die Hand Igen Bomisken Rex, Europe, Lect. Il, and for much that is Val. Vilai, Guthrie Savinus Priv. Various subsequent changes took place from time to time in the constitutions of many of these cities, voluntarily in some cases, and in others in consequence of internal disorders or open revolt against Born, and changes also occurred in the relations with that city of themselves and their citizens, new privileges being conferred in some cases, and in others existing privileges being withdrawn or restricted. And doubtless, too, there was constantly going on a gradual assimilation in the main between the constitutions of the various cities. Without entering into these matters in detail, and without stopping to discuss the consequences of the Lex Julia Municu policy which conferred the Jew percent of Itatu upon all Italians, it is sufficient to say that these cities or urban communities, as they are sometimes aptly called, bore the common name of civitates or repaliki and included two general classes, municipia and colonus under which were several subordinate classes, such as civitates fundero prefectured by etc., each urban community possessing a more or less independent constitution, with its own magistrates, having jurisdiction, and even with power, more or less limited, of making its own laws. To each town was attached a district called territorium or sometimes recto. At the time of the complete development of the Roman constitution, towards the close of the Republic and during the first centuries of the Empire as Savina points out, the whole soil of Italy outside of the city of Rome was included in these urban communities, and every inhabitant of Italy belonged either to the city of Rome or to one or other of these urban communities. The provinces, on the contrary, had originally very various constitutions. They had, however, gradually approximated to the municipal system of Italy, although in them this system was not carried out so completely and thoroughly. In the time of the great jurists, in the 2nd and 3rd centuries of our era, the proposition just now laid down in regard to Italy could almost be applied *, the subject of the Terrius
Hold on, guys. I'm gonna skip up. To be honest, I don't really care too much about that part, but I'm gonna get to, oh gosh. Okay. Real estate persons. Okay, we don't go there, but I'm gonna start up here. All right, let's go.
In Eastern countries, not only to Europeans residing there, but also among natives belonging to different races, for example in Turkey and India, and to some degree it is applied in this country in the case of the North American Indians. 14. ID. Local ZIRWB and Ciotoms. But the feudal system, besides fusing the different races dwelling within a given territory, and therefore rendering impossible the application of race descent for the determination of personal law, had done another thing. It had broken up continental Europe into a vast number of petty sovereignties exercising authority more or less independent over territories, each possessing its own customary law, and had thus rendered possible, in course of time, the rehabilitation of the old Soman principle of domicile. The vast number of legal territories into which the soil of continental Europe was split up seems at this day almost incredible. France, where the feudal system flourished most vigorously, was divided in the first instance into the pays de droit crit * and the pays de droit coutumier * and the latter in its turn into many legal territories, so that prior to the adoption of the Code Napo 1 the number of local customs exceeded 300 and according to Beaumanoir the customs were so diverse that one was not able to find in the Kingdom of France 2 stellenies which in every case used one and the same custom. The rise of free cities contributed to the same result. Gerardus Corselius writes to Burgundus that there were as many different sets of laws in the Netherlands as there were cities. In Germany the state of things was carried to the extent of dividing sometimes the same township or city into several local customs thus there coexisted in Breslau until Jan. 1840, 5 different particular laws and observances in regard to succession, the property of spouses, etc., and the application of which was limited to certain territorial jurisdictions. Not unfrequently, the law varied from house to house, and it even happened one dimulumbe, and enstis, c. chap. I that one house was situated on the borders of different laws, to each of which, therefore, it belonged in part. 15. ID. Real and personal statutes, return to Dom Loyal. The necessity for some uniform principle for the application of these local laws to constantly recurring legal relations early became apparent, and the doctrine of real and personal statutes was invented with domicile as the basis of the application of the latter. Hence domicile came to be discussed to a large extent by the continental jurists, and to be frequently used for the settlement of conflicts of local laws. 16. ID. Codification and poiotio al nationality. In recent times codification has in most European countries stricken out local customs, and replaced them with uniform national laws, and the field of the conflict of laws has therefore become largely international instead of domestic, as it originally was. Moreover, several European nations have by positive 1 Italy. Code, Preliminary Article 6. So too Belgium. The principle of nationality prevail be in the codes of many of the Swiss cantons. See Solden, de Renflonence de la loi d'origine et de la loi de domicile snri tad et la capacité de personnia and droit international privy, c. 9. Whether, and, if at all, to what extent, the French Code establishes the principle of nationality, are questions of no little difficulty and dispute. Most of the writers think it does, but there is high authority to the contrary. Art. 8 of the Code Civil provides, les lois consment I tat et la capacity de personas are gisant les fran ace, famiri and citant and pays stranger, and this is generally construed to apply to all Frenchmen in foreign lands, whether permanently or temporarily resident there. Some, however, refer the word resident to temporary residence alone. In contradistinction to domicile, and argue that no new rule is introduced by the provision quoted. With reference to foreigners in France, the Code Civil is still less explicit, and furnishes 2 texts, namely, Art 11, El Tranger Jouer en France de M6 Mes droits civils ko qui sont au serrant aords auxiliary. 16 Fran 9 Ace par les traits de la nation que l'acui oid stranger appartiendra, asterisk and Art. 13. El Tranger qui aura t admis par la gouvernement of difference of opinion appears. As it is impossible here to state the various theories, the learned reader is referred for further information to the following among other authorities: Laron, Droit Civil in T2, No. 97 et eq. Fien, Droit int. Priv. 11, c. 1, Perdier Vodden's translation, and Note 1, p. 76. Brocker, Cours du Droit int. Priv. NOS 58-66, Asser et Bivier, El Mens de Droit int Priv. NOS 28, and Demangiv of Laws, 7, Chap. I legislation discarded the principle of domicile in the determination of private international questions, and substituted for it the principle of citizenship or political nationality. Domicile has in those countries thus ceased to have the importance which it once had, although it is still resorted to for the settlement of many questions of municipal law. While, therefore, its discussion is omitted from many of the recent European treatises on private international law, it is contained in many of the works on municipal law, notably in the numerous explications of the French Code. 17. Domicile in British Jane Riapandino. Turning now to Great Britain, we find that the notion of domicile is of quite recent introduction into the jurisprudence of the countries composing that realm. Indeed, it is asserted that the word itself, so little was it known, did not find its way into English dictionaries until about a half-century ago. Alweaf law of Holland is substantial J the same. Asser et Riviere.
Listen closely to this, guys.
EU. No. 28. It may be added that among continental writers the doctrine of political nationality, as the basis of personal law, has been rapidly gaining ground during the past few years. In this country and Great Britain it never has been recognized, and whether it ever will be is, to say the least, very doubtful, the principle of domicile being so firmly rooted in our jurisprudence that positi legislation would be required to remove it, and to induce the late number of legislative bodies, which would have to pass upon the subject, to act would be an undertaking of no small magnitude. Round on domicile, pp. 9-11 he says, the word domicile is of modem introduction into our language, not being found in dictionaries published as far back as Johnson's, but in Todd's edition he inserts it, and writes it Domicile with an E, and quotes it from an old book called Brevin Saul and Samuel at Ender, p. 808, where there is this passage: this famous domicile was brought with their appurtenances in one night from Nazareth, over seas and lands, by mighty angels, and can, if honored with a vid, with an offering, and with a vow, cure in a moment all diseases. Todd's edition was published in 1827, but in an earlier work by Mason, 1801, entitled An Addendum to Johnson's Large English Dictionary, the word domiciliary occurs, which he renders as adjective, tecumdomedly French, intruding into private houses, and says in a bracket, This word is a new offspring of the French tyranny * which Todd refers to, but seems to plume himself upon having discovered so erudite an authority as Brevant for the use of the word domicile, which was, in fact, the first NSE of the French word in an English composition, and Brevant was not an Englishman, but a native of Jersey, although he graduated at Oxford, and was afterwards Dean of Lincoln, and therefore, allowing all honor due to Mr. Todd's industry, this I look upon as an accidental use of it, more particularly as the natives of Jersey speak French, and that it did not obtain till the year 1880, at the earliest, in common use, except in America, and not then common, for in 1827 he was put to the necessity of searching for it in such a recondite authority. He admits, moreover, that it was not to be found in our lexicography, and says, Bork uses the chap. It was used by the courts much earlier. Gleave Baron Pollock, speaking in 1864, says it is somewhat remarkable that * domicile is now very frequently the subject of discussion in our courts, and as we have more than once observed, the word is comparatively entirely new to the English law, for neither it nor the notion it conveys belongs to anything English. The word * domicile is not to be found in Viner's abridgment, Bacon's abridgment, Coman's digest, or in English law books from Bracton down to Blackstone. To Latin word as if he bad not known the English. Yettel, in his * Law of Nations, treats of the subject of settlement in precisely the flame manner as domicile is now treated of at page 108 of his work, and as the French word domicile was translated settlement, hence we may infer that although the word itself was not used at the time in England, the middle of the 18th century when he wrote, yet the subject was then discussed among jurists, although it had not monopolized so much attention as since. We, however, find the word used as an English, or at all events as a Such, word in the Dictionary of Decisions for 1818. Lord Poundleton SLG's F notes, p. 199 in Littleton's Latin Dictionary, he translates it thus, domicilium * domiolim, onfrip behau xtf/ui, a mansion, a dwelling house, an abode, titia, Cicero. The word * mansion certainly signifies a fixed residence, for although it may be let, yet it is usually something belonging to the family *, and likely to be retained as a residence. The next word, dwelling house, might be any house, so might the word abode, but the word seds, as used by Cicero, probably referred to the yellow residences in the vicinity of Bourne, that is, a place of retirement, or what we, probably from the same word, call a seat, and there is no doubt that a country seat usually answers the due *scription of a domicile in the Rev. J.G. Wood's very pretty little work, entitled The Common Objects of the Seashore. The following passage occurs at 18 p. 115, showing plainly in what sense the word domicile is taken by a scholar who I be not H. lawyer. These creatures, soft-tailed crabs, are generally called hermit crabs, because each one lives a solitary life in his own habitation, like Diogenes in his tub. The species here given is the common hermit crab, Vigorus bimhardus, and the particular individual is inhabiting a whelk shell, a domicile, that is in great request when the creature grows to any size. It should be observed, in reference to this passage, that the creatures in case * should make the shells of deceased univalves their home as long as they answer their purpose, and therefore the word
They
domicile is
moving
used
just
by
like
Mr.
crabs. That's why they
Wood
crabs,
in
huh?
the sense of home, which these shells undoubtedly are to
Just
the
like
crabs.
the crab.
The word domicilium is used by Ortu lip, il cap 6, s. 24, where there is this passage, Romania legibus altern posterioribus domilium quidem transfer licbat. The Roman law here referred to is as follows, municipis sunt liberti et in eo loco ubi ipsi domilium suft. Voluntate tolerunt, Ne aliquod easy hoc origini patroni facient pers judicium et entrobiquinu rarabusat stringuntanr. Digest, lib. Ltid. 1 ad municipalum et de incoles. Leg. C. 2. In the translation of Grotius by M.R. J. Barbiroch, in 1788, the word domicilium is translated habitation. The above quotation is given for what it is worth, as containing some matters which are of interest, although not stated with entire accuracy. Sp. Cap Davial, 2 HNRL and Cold 985, 1018. The same effect is the remark of Lord Campbell in Thomson v. The Advocate General Carrot.
Hold on, guys. I'm going to go up to page 22 real quick. Hold on a second.
And that, however, and Court of Chancery during the next 5 or 6 years, however, and that therefore the loco 9 are advocates of great celebrity, Sir John Scott, afterwards Lord Eldon, and William Alexander, afterwards Lord Chief Baron, being on one side, and Sir Hay Campbell and Charles Hope, both afterwards presidents of the Court of Session, on the other. The Court of Session had decided, first that the
East
decedent
India
Major
Company,
Bruce, whose domicile of origin was Scotch, being in the service of the East India Company, had his domicile in India, that is, by fiction of law,
fiction
or
of
at least in
law,
legal effect, in the province of Canterbury, and second carrot that as his effects
legal,
were all
being
either in
fiction of
England
law.
or in India, distribution must be in accordance with the law of England. The loco 9 ret city. Lord Thurlow, in his opinion delivered at the time of giving judgment in the appeal, went into a discussion of the grounds of the judgment of affirmance which was pronounced, saying that, happy face, the true ground upon which the cause turned was the deceased being domiciled in India. And that therefore the law of England furnished the correct rule of distribution, not because it was the lex loci ret city carrot but because it was the lex domicile. This case has, happy face, ever since been held to have fixed the law of Scotland upon this subject, on the basis of the law of nations. Carrot the judgment. However, having been simply an affirmance of the decision of the Court of Session, and nothing else appearing upon the record, as the case appears in the Scotch report, its grounds might be misapprehended but for the fortunate preservation of a stenographic report of Lord Thurlow's speech. This celebrated case having been followed in the House of Lords and Court of Chancery during the next 5 or 6 years by the equally celebrated cases of Hogg v. Lashley Balfour v. Scott Amani v. Bingham Bimp v. Johnstone and others, in which not only was the principle of domicile applied, roll, Ertzen, op. Cu. p. 121. Ings before the House of Lords in 1792. This case was before the Scotch and the speeches of Lord Eldon in Mob Conratov session and the House of Lords ing judgment in 1802, and again in several times. It is reported, FAC Call. 1804. 7th June, 1791, Morrison 4619, and FAC Call. 15 November. 1787, Morrison again, IB, 16th June, 1795, Morrison 2379, 4617. House of Lords, 11th 4628. The facts are given at length, April, 1793. Robertson, Op. Cu. 203. And the case discussed by Robertson, Robertson, Op. Cu. p. 152, and Apop. Cu. pp. 126 etiac. He also gives Pendice, p. 468. Appendix, pp. 391 to 467, the proceed * 3 yes. June. 198. But its nature and grounds discussed, The attention of the profession in both countries was attracted to the subject, and thenceforward cases involving the principle became numerous. 20. Domicile in American jurisprudence. In America, the subject of domicile was first discussed in the case of Guyer v. O'Daniel, decided in 1806 in the Court of Common Pleas of Philadelphia County and reported in a note to the case of Decis Batts v. Bergier. The opinion delivered by Rush, President Judge, recognized and followed the law laid down in Bruce T. Bruce, and the case has ever since been looked upon as a leading one. Like the earlier cases in England and Scotland, it involved the question of the distribution of the personal estate of a decedent. And as in those countries, so in
This is how they
the
take your
principle,
family's
once
land
having been
and
recognized,
property. When they're deceased, the information is taken into court. It's very important to understand this. I know this may be a little bit boring, but hey, I'm bored myself, just like listening to it again. But I want you guys to really get this.
Was quickly appreciated by
Very
the profession
important
and applied to the
I'm gonna make some
determination
tea,
of
guys. I'll be
cases
right back.
involving a great variety of questions. 21. The division of the United States into a great number of quasi-independent states, the vast colonial possessions of Great Britain, the increased and increasing value of personal property, and the greater freedom of migration brought about by improved means of locomotion, have rendered cases involving the principle of domicile of frequent occurrence in those countries. The most powerful minds in the profession on both sides of the Atlantic have been applied to the consideration of the subject, and notwithstanding the occasional conflicts of opinion upon particular points, the General Prin 11 Binney, 885, 849 note. It is relating to the Constitution and Piof of Trey that prior to the C.G. asterisk, in Arnold Domicile, has been frequently quoted and Bam Savi. The United Inns. Co. 1 referred to in succeeding cases and in John's. Ca. 868, 1800, opinion by textbooks, and has, it is believed by Kent, J. The principle of domicile in the writer, had not a little influence in qualified form, see infra, c. 2, 26, moulding the American, and to a smaller and even under the name of domicile, extent even the British jurisprudence had been applied to the determination on the subject. For example, President of national character in time of war, Rush's definition of domicile is substan. But it was not through this class of tiley that adopted by Phillimore, and cases that domicile gained admission to can be traced in many of the cases, the general jurisprudence of this country. American and English. It is also Guyer v. O'Daniel, however, although adopted, with Phillimore's amendment, decided by a court of inferior jurisdiction by Calvo, Manuel de Droit int. Pub. Et. Containing as it does a clear state priv. 197, as the most exact definement of many of the principles of law given. Siples of the law of domicile have been explicated with considerable clearness, and a system has been built up differing in some respects from the doctrine of the Roman jurisconsults and the modum civilians. Between the British and American authorities, however, there is, except in a few particulars, a close correspondence, brought about in great part, we are glad to believe, by the influence of the writings of that eminent judge and accomplished jurist. Judge Story. 22. Bibliography. There are in the English language but 3 substantive treatises upon the law of domicile. For 90. The Law of Domicile, by Robert Phillimore, advocate in Doctors' Commons, and barrister of the Middle Temple, London, 1847. Reprinted in the Law Library, Philadelphia, 1847. This a work of great learning and industry, in which are collected, perhaps, all the English cases decided up to that time, together with some of the American cases, and with copious references to foreign authorities. An appendix contains extracts relating to the subject of domicile from the writings of Mainochus, Mascardus, Poitiers, Binkershoek, and Cochin, and from the French and Sardinian codes, together with the judgments in the leading cases of Bruce v. Bruce, Bimp v. Johnstone, Somerville v. Somerville, and Goyer v. O'Daniel. Altogether it is a very valuable book, and has always been cited with the greatest respect. This work was subsequently incorporated bodily, and with scarcely any additions, in the fourth volume of the work by the same author on international law, which has run through several editions, the second edition of the fourth volume, appearing in 1874. It is to be regretted that this learned author and distinguished judge did not see proper to rewrite his exposition of this subject, in view of the large number of cases which had appeared in the interim, or at least to incorporate the most important of them into the body
English
of
law.
his text.
Grand Rising.
Second, a treatise on the English law of domicile, by Oliver Stephen Round, Esq., of Lincoln's Inn, Barrister at Law, London, 1861, 16 mo, pp. 124. This does not pretend to be either an exhaustive or an accurate treatise, but was written, as the preface tells us, carried chiefly in vacation, without the aid of books, but of notes only collected at spare moments. The aim of the author seems to have been rather to happy face, touch upon every branch of the subject than either to collect all the cases or to weave them into a systematic exposition. The work is but little known, and is to be found in but few libraries in America. It has been cited in only several English cases, and does not seem to be relied upon as an authority. Third, the law of domicile as a branch of the law of England, stated in the form of rules, by A. V. Dicey, B. C.L., Barrister at Law, and formerly Fellow of Trinity College, Oxford, London, 1879. This is a clear and systematic discussion of the subject exclusively from the standpoint of an English lawyer, and notwithstanding the almost entire absence from it of any notice of American cases, the work is a valuable one to American lawyers because, among other reasons, of its excellent analysis of fundamental notions. The author does not, however, limit himself to the consideration of domicile per se, but devotes more than one half of his space to an examination into its legal effects. His work is thus substantially a treatise on the conflict of laws from the standpoint of domicile. Another work may be here mentioned, although it considers but a narrow branch of our subject, namely, a treatise on the domicile of Englishmen in France, by Henry W. Cole, London, 1857. It collects and discusses with clearness and ability the authorities, both French and English, which had appeared up to the date of its publication upon the subject of the acquisition of domicile by foreigners in France. The author appears to have had some special qualification by reason of his experience in litigation involving the subject matter of his treatise, and although this might be supposed to bias somewhat his opinions and to detract from his judgment while adding to his information, yet his statements are fair, and his conclusions are given without apparent partisanship. 28. Each of the several treatises in the English language once since Professor of Law at Oxford on the conflict of laws or private international law contains a chapter on domicile, the earliest, with the exception of Henry on foreign law and Lievenoer on the contrariety of laws *, which is indeed in size only a tract, and, although containing much that is suggestive, is neither a full nor a systematic exposition of the subject of the conflict of laws, is M.R. Justice Story's Commentaries on the Conflict of Laws, which originally appeared in 1884, and has run through 8 editions. Chapter 3 is devoted to a discussion of national domicile, and is by far the most lucid exposition of the subject in the English language. It has done more than any other work to bring into harmony the decisions of the courts on the subject, and in a large proportion of the cases on both sides of the Atlantic has been cited and relied upon by both counsel and court. Owing, however, to the plan of the work, it was possible only to state conclusions and refer to authorities, without entering into any minute discussions. 4 years later appeared, in England, William Surge's learned commentaries on foreign and colonial law, in 4 large volumes. This work is a great storehouse of profound and accurate information upon the subject expressed in the title. It is unfortunately inaccessible to most American lawyers. Chapter 2 discusses the subject of domicile with great learning and ability, in the light of the foreign authorities principally. Following this in England were the treatises of Westlake, Phillimore, and Foot * on private international law, in each of which the subject of domicile has been separately considered. And in this country has appeared the well-known work of Dr. Wharton on the conflict of laws, which has passed 1c and for UF Note 7. Substantially a new work, being entirely the contrariety of the positive rewritten, and as the author says in his Laws of Different States and Nations, preface, differs in numerous points from that by Samuel Livenover, New Orleans, published in 1858, to which it stands in 1828 *. It contains no discussion of lieu of a new edition. Domicile. *, a concise treatise on private *. There are 2 editions of Westlake, International Jurisprudence, based on the first API, hearing in 1858, republished the decisions in the English courts. In the Law Library, Philadelphia, London, 1878. 1859 the second, appearing in 1880, is a treatise on the conflict of Chap. I through several editions, and which also devotes considerable space to the discussion of our subject. To these may be added the English translation by Guthrie of Savinger's volume on the conflict of laws, where the subject of domicile is considered at some length, with the historical and exegetical accuracy and learning which characterizes the writings of that prince of modern jurists. This list may be still further increased by adding a large number of works on special subjects to which the principle of domicile is more or less applicable. Particular mention, however, should not be omitted of the excellent collection Gage, and had its origin in the case of Odwin v. Forbes, decided by the Court of Demerara, over which the learned Anihor presided. The book is particularly valuable with respect to the subject of domicile, because of the opinions which it collects of various eminent Dutch jurists, such as Corvinus, Grotius, De Witt, Grenougen, and others. These opinions are taken from the * Hoyuwen's consultation and the New Netherlands at Bespoke, and, so far as they were originally written in Dutch, translated into Pound Anglais H. Jarman
Originally
on
in
Wills,
Dutch.
Volume I. Ch. 1. See particularly the notes contained in the several American editions. Kent's Commentaries on American Law, Volume ILPP. 227 note, and 430 note. The D.T. Musson of the subject of domicile by this learned writer is brief, being confined to a few pages. Aneland on Attachments, ch. 10 McLaren on Wills, Volume I. ch. 1. Parsons on Contracts, Volume 2. pt. 3, ch. 2, 4. Parsons on Maritime Law, BK. 2, ch. 1. Parsons on Marine Insurance, Volume LCH. 2, 2. Bedfield on Wills, 4, ch. 1. Limits of their operation in respect of place and time, Edinburgh, ed. Flood on Wills, in Bundo, and in French,
Sorry, I wanted to go
Desquirin's Trait Introduction. Chap. I of English and American authorities and discussion of the subject contained in the first volume of Hare and Wallace's American Leading Gases.
cases.
24. Among the works of continental writers treating solely or largely of domicile may be mentioned Lauterbach's Dissertatio de Domicilio, and Thomasius' Tractatio de Jaga. Bundo, and in French, Desquirin's Traits du Domicile et Absence, and the several theses pour le doctorat, of Ansel, Chavons, Buzel, and de Fontgoffier. The subject is discussed at greater or less length by many of the older as well as later continental writers. A list of the most important is Given
Okay, we're gonna go
Bohire,
past the list.
Orpsovio, Domat, Van Leeuwen, Pub,
Excellent.
Et Priv Carat, Verb, Domicil, Chap, Zachariah, Chapter 2. Uses of domicil. 25. General remarks. Before entering upon a consideration of the general subject of domicil, its definition, nature, constitution, and change, and the ordinary evidence by which its change is shown, etc., it will be well to take a brief survey of the general field, or perhaps it would be more accurate to say the several fields of jurisprudence in which it is usually applied for the determination of legal relations. To do this with any degree of detail would itself require a volume, and moreover such a discussion would more naturally and logically follow than precede the consideration of domicil per se. It is the object of the writer, however, here only to outline briefly the various uses to which in American and British jurisprudence the principle of domicil is practically applied, for the purpose, if possible, of approximately estimating the values as authorities of the several classes of cases hereafter to be cited in the body of this work. From this chapter, therefore, the continental authorities will be, in the main, omitted, and the several topics will be discussed as succinctly as possible, with references only to leading cases and textbooks, to which the learned reader may refer for more elaborate discussion and fuller lists of authorities. 26. Domicile in public international law, national character.
Domicile
Character
law.
general, the determination of the national character of a person, as subject, enemy or neutral, in time of war, depends upon his domicile. The general principle being
In
that
time
one, the
of war
vigilantia,
depends on the
1C.
domicile.
Rob. 1. The mile and 8. 726. Livingston. Mary. Emden, ID. 17. The Harmony, 2 ID. Land Inns. Chap. To cripple the resources, Chap. 2. Every person is to be considered as belonging to that country where he has his domicile, whatever may be his native or adopted country. This principle is usually applied in prize cases, in the determination of which, however, peculiar considerations prevail. The object of prize capture in war is to cripple the resources of the enemy, and thus indirectly abridge fighting by depriving him of the sources of his wealth and the means of supplying himself with the sinews of war. To attain this object, not only is the property of every person domiciled within the territory of the enemy held liable to capture, but also the products of the hostile soil, and all Johanna, ID. 159, the Friend Scaft, Wynne et al., claimants, 8 ID. 14, United States v. Gillum, 11 How. 47, the Prize Gases, 2 Black, 685, the William Bagley, 6 Wow. 877, Mitchell v. United States, 21 ID. 850, United States v. Farragut, 22 ID. 406, Desmaire v. United States, 98 U. A 605, the N. Green, 1 Gall. 274, the Joeif, ID. 2 Payne, Phillimore, int. L. Toll IILPP. 128, 608, Twiss, Law of Nations in Time of War, S. 152 ET $EG,
Law of Nations in time of war.
Ins. CH. 5, 2, R2, Viewer, March. Ins. Volume L. Lect. 5, Parsons, March. Ins. VDI. CH2, 2, ID. Maritime L. BK. 2, CH. 1. In Livingston v. Maryland Inns. Co. Tupra. Story, J. THNS clearly states the doctrine, *, it is clear, by the law of nations, that the national character of a person, for commercial purposes, depends upon his domicile,
Mm-hmm.
But this must be carefully distinguished from the national character of his trade. For the
Why it's
party
important to
may
have
be a
these people
belligerent
coming in.
subject, and yet engaged in neutral trade, or he may be a neutral subject and yet engaged in hostile trade. Some of the cases respecting the colonial and coasting trade at enemies have turned upon this distinction. But whenever a person is b. the character of the country I attaches to him, the rule has been applied with equal impartiality in favor and against neutrals and belligerents. It is perfectly immaterial what is the trade in which the party is engaged, or whether he be engaged in any. If he be settled bona fide in a country with the intention of indefinite residence, he is, as to all foreign countries, to be deemed a subject of that country. Without doubt, in order to ascertain this domicile, it is proper to take into consideration the situation, the employment, and the character of the individual, the trade in which he is engaged, the family that
Let's hear that again.
he possesses, intention of the character of the country I attaches to him. The rule has been applied with equal impartiality in favor and against neutrals and belligerents. It is perfectly immaterial what is the trade in which the party is engaged, or whether he be engaged in any. If he be settled bona fide in a country with the intention of indefinite residence, he is, as to all foreign countries, to be deemed a subject of that country. Without doubt, in order to ascertain this domicile, it is proper to take into consideration the situation, the employment, and the character of the individual, the trade in which he is engaged, the family that he possesses, and the transitory or fixed character of his business, are ingredients which may properly be weighed in deciding on the nature of an equivocal residence or domicile. But when once that domicile is fixed and ascertained, all other circumstances become immaterial. S. Phillimore, int. L. First ed. Vol. IIL. p. 608. Collaterally, it is applied in other cases also, particularly in cases of marine insurance. Marriott v. Wilson Supra, Bell v. Bud, Upra, Livingston R. Maryland Inns. Co. Supra, Elbers R. United Inns. Co. Supra, Dewar, March. INS, Supra, Amold, ID, Supra, Parsons, ID, Supra, ID. Maritime L, Supra. Authorities, interests and property in or connected with houses of trade established within the hostile territory, no matter to whom they may belong, whether friend,
No matter to whom
enemy,
they belong, huh?
or neutral.
Huh.
Cases
Yeah.
of this description
Even if
are
it ain't
usually
yours.
decided in the courts of the belligerents themselves, and at times and under circumstances which preclude the fullest investigation of all the facts bearing upon the ownership of the thing captured, and particularly of the facts bearing upon the animus of the claimant. For all these reasons, and because, moreover, there are great temptations, and great possibilities also, for the commission of frauds by claimants, prize courts have leaned strongly in favor of captors, and principles have been applied by them, which do not prevail in other classes of cases. The development of the law of prize as it has been applied by the British and American courts is due mainly to the learned and luminous judgments of Lord Stowell at the close of the last and the beginning of the present century, and the leaning of the mind of that great jurist was, as has been pointed out by high authority, strongly in
Being a
favor of
ruler.
captors. As a single
Right, brother?
instance may be given his remarks, in the harmony registered upon the subject of length of residence as indicative of domicile, in which he propounds doctrine wholly at variance. Vrou Anna Katharina, ID 161, 30. The captors' residence, for example, hogsheads of Sagoto, Boyle, 9 Cranch, in a belligerent country will condemn 191, the Cray Jacket, 5 Wall 842, 1 the share of a neutral in a house trading Kenscom. P. 74, Lawrence's we in a neutral country, hut residence in Tun, 2d ed. P. 576 Etiac, Phillimore, a neutral country will not protect the int. L is ed. Volume IILP. 607 share of a belligerent or neutral in a asterisk the vigilantia. 1G. Bob. 1. The commercial house established in a Bell Portland. 8 ID. 41. The Antonia Jolligerant country. In a great maritime. Hannah. 1 wheat 159. The Friendscap country, depending on its navy for its. Marrera. Claimant. 4 ID. 105. The glory and its safety. The national bias Cheshire. 8 wall 281. The San Jose is perhaps so entirely in this direction. Indiano. 2 gall 268. 1 Kenscom. That the judge, without being conscientious. P80. Vimery. In hell. Volume 3 of the fact, must feel its influence. How dash, P.
Nope.
605 ever this may be, it is a fact of which I
Hold on,
7
God, I wanna
Marshall,
get to this
William
part.
Scott as I do E caret airy truly great to investigate rigidly
Yeah, it's
the
reading real
principles of
crazy. Let me
man,
fast
are them
forward.
attentively without
Actually, I want to
perceiving
read this part.
William Scott as I do E, P80, Hannah, 1 wheat 159.
Okay, it says, it's reading, the book is going all across, so let me read this part. It says residence, for example, is a belligerent country. It will condemn the share of a neutral in a house, trading in a neutral country, right? But residence in a neutral country will not protect the share of a belligerent or a neutral in a commercial house. When in a commercial house established in a belligerent country. I bring my grandbabies, and Lord, I swear these kids, I don't know how they stay, having some kind of runny nose sometimes. All kids, you got to be so careful with children, guys. And when this weather's changing, like, oh, it seems decent out, it's nice out. You got to make sure they are wrapped up really good, because this weather changes at the drop of a hat. There's all types of things going on. The kids need to have things covering their heads, making sure they keep socks on, even if they don't want to put them on, they have to have these things on. My grandbabies love to be barefoot. They running through. I was at my daughter's house. They just running through. I'm like, put some socks on. I got to make them put socks on. They don't want socks on their feet. Their mom was the same way when she was little, though. It's so crazy. Kids pick up the same habits as the parents, right? Next thing you know, you got a runny nose because you done ran outside, or the one want to play his truck in the distance. I'm like, Lord. So you got to be real careful when this weather's changing. This is the time for the kids to be sick. And like literally in 2 days, I got sick, and I don't even hardly get sick. I get sinus issues. That's just normal. But man, let's get into this, guys, real quick. So I'm having a little problem with my breathing. So just pay attention. It says in the great maritime country, depending on its navy for its glory and its safety. The national bias is perhaps as entirely in this direction that the judge, without being conscious of the fact, must feel its influence without being conscious of the fact. Yeah, right. However this may be, it is a fact of which I am fully convinced, and on this account, it appears to me to be the more proper to investigate rigidly the principles on which his decisions have been made, and not to extend them where such extension may produce injustice. But they're the ones that are bringing injustice by even being there, like literally being on the area, place don't belong to you, trying to create domicile through these cities and using commercial aspects. So yeah, pay attention, guys.
The Friendscap country, depending on its navy for its. Marrera, Claimant, 4 ID. 105. The glory and its safety. The national bias Cheshire. 8 wall 281. The San Jose is perhaps so entirely in this direction. Indiano. 2 gall 268. P80.
That's the part.
Williams, ER them attentively with chap.
Okay.
2 with the views of almost all of the courts and writers who have spoken on the subject of time in its relation to domicile considered with reference to general purposes.
Squatting.
From these and other considerations it is apparent that cases of national character in time of war should be used with the greatest caution upon the general subject of domicile
we're gonna fast forward again, guys.
by resemblance of commercial domicile to civil domicile.
Ooh, because I want to get to the next document on these Puritans, so you guys can see. Hold on. gosh, I hate to keep looking up. I cannot remember pages. Let me see. Oh. Okay, here it goes. Here we go. I was going to find it. All right, guys. Here we go. Should I go prior to this? I don't want to read this. Yeah, I'm going to have to. Okay, we're going to start here, guys.
Chap. 2 questions of this character are to be decided according to the law of the country. Where the contract arises. But in several late cases there are dicta broadly in favor of the les domicilii. In this country there is a decision of the New York Supreme Court * in favor of the lex loci contractu % and the opinions of
information on marriage and domicile coming up.
Writers in both countries are the same way. As also is the analogy to be drawn from the American cases upon the capacity of married women. In the celebrated case of Saul v. His creditors. Which has been much criticized and much misunderstood. Porter, J. used language which when rightly interpreted amounts to this, namely, that, when the defense of infancy is set up to a contract, the Louisiana courts will apply either the les domicilii or the lex loci contractu %, as the one or the other will the more in Sotomayor v.
This was just a
DeBarros,
mirage.
L. R. 8p. D1, 6, Cotton, L.
Hold on, guys.
J. said, it is a law of domicile C 190, 3 pt. 5 Mart. NS.
Okay.
And those which fix the state and condition of man, are personal statutes, and follow and govern him in every country. Now, supposing the case of our law fixing the age of majority at 25, and the country in which a man was born and lived previous to his coming here placing it at 21, no objection could be perhaps made to the rule just stated, and it may be, and we believe * would be true, that a contract made here at any time between the 2 periods already mentioned would bind him. But reverse the facts of this case, and suppose, as is the truth, that our law placed the age of majority at 21, that 25 was the period at which a man ceased to be a minor in the country where he resided, and that at the age of 24 he came into the state, and entered into contracts, would it be permitted that he should in our courts, and to the demand of one of our citizens, plead as a protection against his engagements, the laws of a foreign country, of which the people of Louisiana had no knowledge, and would we tell them that ignorance of foreign laws, in relation to a contract made here, was to prevent them enforcing it, though the agreement was binding by those of our own state? Most assuredly we would not. Chap. And tend to support the validity of the contract. And this is substantially the same rule as was subsequently enacted in both the Prussian and the Austrian gods *. The same principle was applied by Lord Romilly in Re Hellman's will registered in fixing the time for the payment of a legacy. Dicey lays it down that the capacity of any person for the alienation of movables depends, so far as the question of infancy or majority is concerned, on the law of that person's domicile. Testamentary capacity, happy face, and capacity for marriage, happy face, will be hereafter considered. 36. Marriage. With regard to the formal requisites of a valid marriage, it is now generally agreed that the lex loci celebrationis furnishes the true test. At least it may be laid down as the general rule, that a marriage celebrated in AC accordance with the formalities required by that law will be considered in this respect valid everywhere *, although it may be added that in some cases also the marriage will be held valid if celebrated in accordance with the formal requirements of the lex domicilii. T.C. Westlake, Priv. Int L. 2d ed. pp. 48-52, Schooler. But with respect to the capacity of the parties to a marriage there has been much discussion and diversity of opinion. 2 principal theories have been held. 1. That matrimonial capacity is determined by the law of the place of solemnization. 2. That it is determined by the law of the domicile of the parties. To these Wharton has
But
added.
isn't marriage, created by the domicile of the two parties connecting. Like when you lay in a bed and you've exchanged yourself with another person, you literally married. You married to that person. That's a spiritual connection. You cannot break. Your little one night stands, all of that. You just committing adultery. You just fornicating. All these things you want to claim or whatever when it comes to what they called it. But if you lay with a person, that person is literally who you're married to. I don't care if you lay to 20 people. You done marry each person. That's what the marriage is. When they bring it into the sanctity of the domicile into law, you're taking your marriage under the wardship of the state. The same exact thing as your birth certificate. Same thing your mama did. Gave you over to the state. Now you're going ahead and committing yourselves. We are committing ourselves. We're combining ourselves with the state in the holy matrimony of a trinity of nativity. Yes, that's what you're doing. Your marriage is a private thing. Why would that be a social character that is implied upon domicile and what's going on in the land? That shouldn't have anything to do with it.
The third, which concerns mainly our own country, namely, that our national policy in this respect is to sustain matrimonial capacity in all cases of persons arrived at puberty and free from the impediments of prior ties. Upon this question, the doctrine of the English cases is in a far from satisfactory condition. The earlier cases were supposed to have settled the rule upon the basis of the lex loci celebration ui, but the later cases have shaken this doctrine, and in view of the recent decision of the Court of Appeal in Sotomayor v. de Barros, the rule may at present be considered to be, that the lex domicilii of the parties is the test, and further, that where the domiciles of the parties are different, that of the man is to govern, notwithstanding that the lex domicilii of the woman pronounces her incapable of entering into the particular marriage in this country it is different, for, although there are some conflicting decisions, it is pretty thoroughly settled that the law of the place of solemnization furnishes the rule. This is in accordance with the very decided opinion of Story *. This instance it may be said that the story can flow of L. 79 ETSEQ 102 national law and not the lex domicilii ETEQ 113 is apt for direction, as also supra is the. Of course, when we speak of a marriage being valid by a particular law, it must be understood that such law is applicable on LG insofar as it permits marriages which are not polygamous, or incestuous according to the generally received opinion in Christendom. Therefore, a polygamous marriage of Americans in Turkey would not, upon the theory of the applicability of the lex loci celebrationis be recognized by the courts of this country as valid, nor would such a marriage in England of Domicil Turks be, upon the theory of the lex domicilii recognized by the English courts as valid. In either case the marriage would be considered as contrary to good morals and the policy of the lex fora and therefore would be deemed void.
Even listening to this, I want you guys to listen closely, right? Remember what it was telling you earlier about the domicile, the land, the war. All these things are, taking place to help with the domicile, coming in, taking or assuming lands, taking over the placement, right? Pay attention.
37. Mutual property rights of husband and wife. The marriage being assumed to be valid, in the absence of any settlement or express contract, the mutual rights of the husband and the wife in immovable property belonging to either of them are of course determined by the lex loci rei city under our jurisprudence, although many high authorities on the continent contend for a different rule. As to movable property, domicile plays an important part. The mutual rights of the parties in the movable property belonging to either of them at the time of the marriage are when the statutes are silent. Questions bring it within the exception on account of the validity of marriages adopt of polygamy. One of the parties must terminate by the JD gentium, the com have another husband or wife living. Mon law of nations, the law of nature as to bring it within the exception on the generally recognized by all civilized ground of incest. There must be such a
here it goes reading crazy. I was going to let this play. I'm going to have to read it, right? It says that when the statutes are silent, questions of the validity of marriage are to be determined by the just gentium. In common law of nations, the law of nature is generally recognized by all civilized people. The law of nature is generally recognized by who? Civilized people. They say I can't highlight this. Take me to the next paragraph. I hate this book that's doing this sometimes. Okay. Right? The law of nature is generally recognized by all civilized persons. It says by the law, the validity of a marriage depends upon the question whether it was valid where it was contracted. Oh, marriage is a contract between you, the other, and also going into the state, right? That whole trinity, right? That you're setting up. It says, by the law of validity of the marriage depends upon the question whether it was valid where it was contracted. If valid there, it is valid everywhere. The only exception admitted by our law to the general rule are of two classes. First, marriages which are deemed contrary to the law of nature, and generally recognized in Christian countries, right? Marriage, which the legislature and the Commonwealth has declared shall not be allowed any validity because contrary to the policy of our own laws, the first class includes only those that are void for polygamy or for incest. That's disgusting, right? But, they did that to, try to build up a culture in the nation, an ancestral nation built amongst ourselves. They're so proud of it too, right? Bring it within the exception on account of polygamy. One of the parties must have another husband or wife living to bring in within the exception of the ground of incest. There must be such a relation between the parties contracting as to make the marriage incestuous according to the general opinion of Christendom. Do y'all hear this freakish, nasty, disgusting crap? Is this serious? Like, seriously, like, these people, when you think about all these deformities and things that you see a lot of times, not only are we talking about the incubated children, right? The ones that are created with false light, nitrogen, radium, put in test tubes, creating these beings. You find out why a lot of them were like some of these midgets. Remember, we read the information on the project, and it told us that they were duplicating and it would make the midgets, like the little small. So this is why when they were cultivating these persons, right? A lot of them were like midgets. Some of them were giants, not the natural giants, but giants that were created, possibly a gene of growth that may have been emitted that was too large, so on and so forth. So the scientific facts of these things have been proven time and time again, right? But let's continue. To bring in within the exception of the ground of incest, there must be such a relation between the parties contracting as to make the marriage incestuous according to the general opinions of the Christendom. It's crazy. And by that test, the prohibited degrees include beside persons in the direct line of consanguinity, brothers and sisters only, and no other collateral kindred. Do you hear this? Like crazy, okay?
Whether it was two classes,
creating
Lacharit Commonwealth, cause contrary to the regulated by the law of the matrimonial domicile, asterisk, which may be described as the domicile
giants,
which
brother,
is contemplated or intended by the parties at the time of the marriage, usually, but not necessarily.
Jeez,
this is the domicile of the husband at that time, but it may be the domicile of the wife,
yes,
if the parties intend to dwell at the place of that domicile, or it may be at a third place, if the parties intend to dwell there. In the absence, however, of proof to the contrary, the domicile of the husband at the time of the marriage will be presumed to be the matrimonial domicile. As to property acquired by either of the parties
crazy, sis. I literally, I was so tired yesterday, guys, and as y'all can see, I don't feel good. I was feeling worse. I feel better. I've been drinking teas and things of that nature. But yesterday I wanted to do a build. I just couldn't get up to it. It was actually kind of on what you're talking about, sis. Showing that the takeovers of the land. We know that all the land was in the woman's name, right? She had the house, she had the property. It was all in her name. So these marriages, this is the same thing. As they were talking about earlier, right? In the war. There were wars, right? So with these wars, in order to take over land as well, of course, they ease in, marry an American Indian, take place on the land and taking their land, assuming their property. These are all things that they were doing. I may get back into that, but I definitely want to show you guys that them even talking about it is disgusting. But let's go.
The marriage, there has been much difference of opinion. The continental jurists generally contend that the law of the matrimonial domicile governs throughout the existence of the marital relation, and applies not only to property owned by the spouses at the time of the marriage, but also to subsequent acquisitions *, but with respect to the latter the doctrine is now settled in this country that they are governed by law of the actual domicile. This was early declared to be the true rule by Story, and is now abundantly supported by the decided cases. In England the question is not settled by judicial decision, and the opinions of the text writers, when expressed at all, appear to be divided. Phillimore, Priv. * Story, Harold v. Weil. 37a. Consternation of marriage contracts. Domicile is also of some importance in the construction.
I hate this read. This I do like to read. Y'all know I love to read, but man, this is saying it said construction of marriage contracts. The construction of marriage contracts.
Of marriage contracts. It is by no means controlling, however,
Yeah, right.
and no definite rule
What is
upon
it
the
then?
subject can be laid down, inasmuch as in the construction of such instruments, just as in the construction of other contracts, a variety of matters must be taken into consideration, and each case must to a large extent stand upon its own circumstances. 38. Capacity of married women to make valid contracts. As to capacity to make valid contracts, much that has been heretofore said with respect to nonage applies also to cover. Tour. Continental authorities assume the personal law, that is, that of the domicile, or nationality according to the new theory. 83 Decisive. In England the question is an open one, with recent dicta in favor of the same view *, but on the other hand it may now be considered as settled in this country, that the capacity of a married woman to enter into a binding contract is to be determined by the lex loci contractiles. This question was examined at length by Gray.
The woman to enter into a binding contract. That you guys understand, right? What's going on here, right? Right? It says, but on the other hand, it may now be considered as settled in this country that the capacity of a married woman to enter into a binding contract is to be determined by the lex loci contractus. So, a binding contract. What is binding? Do you guys follow what they're telling you here? You're binding yourself. We were just speaking on that a second ago, right? Because what it is a trinity. You're binding yourself to a trinity, a holy trinity with the state. You're binding yourself to a holy trinity of servitude, conservatorship, slavery, bound under the husband. They say, oh, the husband is the head of the household. The husband leads. The husband. Well, no man could do anything correct if he didn't have a woman behind him. The right one, the one that knows how to stand, the one that knows how to guide him, the one that is the backbone, literally the backbone of the whole family, that takes care of everybody, make sure they're right physically, mentally, and spiritually. Who does that? Who does that but the woman? Stop playing with us. Give us the credit, right? So here they go, one to take that away by doing what? Putting her into a binding contract, binding her from being the energy, the finite, the infinite, feminine, the feminine energy, right? And taking it away to give all that strength and energy to the man. But no, that's not his job. The man's job is to be physically capable to be instructed as to what he needs to do, right? He needs to lead in certain areas, and he has to have that woman to guide him, to make sure that he is nurtured in his mind, his body, his spirit, his soul, so that he is able to complete what he needs to do. When you have a patriarchal system that the man is controlling, there are so many things that can be affected. You guys don't see what's going on now? All these male presidents, what's going on? They still want a male. They want to keep it in the Baphomet style. Y'all know every president that we had, these men, people talk about Obama and Michael, right? When we talk about these people, that's not the only one. if I pull up every president's wife, I believe except Kennedy, his wife was definitely a true feminine woman, right? There may be 3 or 4 because I don't know them all by heart, but like almost everyone I'm seeing, I'm looking like, oh, that's a man, that's a man, that's a man. They be wearing these scarves. They'll wear these high collars, these little jackets. They always have these little scarves tied around, covering up their little Adam's apple. It's been a game they play on you guys. Patriarchal, papa, the daddy taking the control. Y'all don't understand that? Let's get it.
C. J. In the recent Massachusetts case of Milliken v. Pratt and the result indicated was reached after an elaborate review of the authorities. There are decisions to the same effect in other states. This view has also received the unqualified support of Story and Wharton. 39. Jurisdiction in divorce cases. It is undoubtedly Westgate takes distinct ground in favor poem 100.
Jurisdiction. Look, jurisdiction in your damn case.
1 Fiuemo, 95.
Hold on.
CH. 6. 2. Competent for the sovereign power of any state or country to confer upon its tribunal such jurisdiction in matters of divorce as it deems proper.
You hear this?
And a decree pronounced by a competent tribunal under authority so conferred would necessarily be held valid and binding within the territorial limits of the stato or country whose tribunal it was. But what effect, if any, would elsewhere be given to such a decree, depends mainly upon whether the jurisdiction of the court pronouncing it has been conferred and exercised in accordance with the generally received principles of international law. The test, therefore, of the validity, as to jurisdiction, of a domestic divorce is anything which the lawmaking power chooses to enact, while the test, as to jurisdiction, of the validity of 2K foreign divorces, according to the generally received view, the domicile of the parties the place of the celebration of the marriage is immaterial, and so, according to almost all the authorities, is the place of the commission of the offense. In England there has been considerable...
And it's amazing, right? We keep hearing them talk, in England. I ain't heard them say shit about Europe. Did y'all hear Europe? Anybody heard Europe? No one heard Europe yet, as of yet, but they're talking about all these domiciles and the parliament, the commonwealth, the common law. We talk about ecclesiastical, all these different things, right? When we read all of our old books, every old book that I've shown you guys, and we've always gone through it, always tells you what London, Boston, New York. We're not going to get into that because you guys are pretty clear on that, I'm sure. If y'all clear on that, put a 1 in the chat. Anybody that's clear on that, put a 1 in the chat. Now, we're talking about England, right? And we're talking about domicile that comes to the rights and properties of land. These land disputes that are always talked about over time are where? Here in America. No damn where else do you hear about, they had these issues. They were still in the land over here in Europe. They went over and, they did that. Yeah, Europe had to fight with that. Yeah. Of course, the Etruscan Moors, of course, they were fighting in Europe. They were fighting, when they were invaded, taken over, which made them come through here, coming through our England, old England, the ancient land of Canada, Toronto, Virginia, Maryland, New York, all of that, right? Where they have us misconceived as far as our direction because this map has been flipped in the minds of these people because they was flipped. They didn't even know what they was doing or where they was going. They thought north was south, south was north. Shit, y'all don't know direction. They didn't know any of this stuff, guys. Let's not get into that story. But keeping in mind, when we're talking about all the domicile and the placement and the takeover of lands and things, everything we're going over here, we're talking about England. We're looking at the Toronto area. We're looking at the Seneca Nation. We're looking at the kings and queens of America, once again. So let's not be deceived. Pay close attention.
Confusion in the decisions and judicial expressions of opinion upon the question of jurisdiction. Until the Statute of 20 and 21 Vict. C. 85, which went into operation in 1858, divorces of vinculo could be granted only by Act of Parliament. Since that time, they have been grantable for certain causes by a special court created by that act, and since become one of the divisions of the High Court of Justice. The jurisdiction of the court is, therefore, purely statutory, and was, until recently, generally understood, although the matter was not considered as settled, to depend upon the domicile of the parties. But in Niboyet v. Niboyet *, which was decided by a divided court of appeal, it was held to depend upon residence somewhat short of domicile. This, however, is merely the result of the one Savigny system, etc. Trans. P. Construction of the Act of Parliament conferring jurisdiction upon this particular court, and does not in the
We got the
slightest
Ford
degree
again,
affect the
guys.
doctrine held by the English
So we
coitus
get
with
to the next
respect
book
to
in
the
a second.
international validity of foreign divorces. Indeed, the English courts have constantly refused to recognize as valid Scotch divorces pronounced upon jurisdictional facts similar to those upon which the English divorce court finds itself compelled by Act of Parliament to assume jurisdiction. With respect to foreign divorces, it was formerly supposed that a marriage celebrated in England could not be dissolved, except by Act of Parliament, and it was
They
therefore
gonna tell
held
you
that the decree
if you can get out of this marriage. Well, wait a minute. I don't know if I want you out this marriage, because see, if you get out of this marriage, it might mess up what's going on with the land and domicile that we have after we've gotten you guys under this servitude of this marriage license. So we got to make sure we can't just let you do what you want to do, because there's a reason of this control, right? Oh, hold on a second. This thing going so slow. I don't have pages written down, guys, so give me a second. Should have did that. I was just jumped out. Okay. I think we need to at least get into this. We go back a little bit. I got all these footnotes. God dang, then half of them ain't reading right. That's so annoying. Okay. Oh. No, I don't want to get into the will part. Hold on, guys. Let me go back down. I'm gonna just start here. I'll fill you in if you can't catch up. Let me know.
Chap. 2 declared in favor of the former, and Phillimore * has followed him. But this view does not appear to be maintained by the weight of the authorities either in England or in this country, which hold the doctrine that capacity to make wills, as well as all other matters of testamentary validity, is to be determined by the law of the domicile existing at the time of the death of the supposed testator, as regards the formal execution and revocation of testio. The execution of the will is to determine questions of his testamentary capacity in preference to the ux domicile at the time of death, although he has been usually understood in a contrary sense. It may be added that in Moultrie v. Hunt, 23 Y 394, Story was understood both in the majority and minority opinions of the court to have special reference in 473 to testamentary capacity. But out of deference to the generally received interpretation of Story's language in 465, the statement has been made as above in the text *int L. Vol 4. No. 863, Dicey, DOM. P 311, possibility of question, personal representative of the deceased. To the court of the domicile belongs the interpretation possibility of question, that the administration of the personal estate of a deceased person belongs to the court of the country where the deceased was domiciled at his death.
You hear?
All.
Do you hear? Listen. Put beyond all possibility of question that the administration of the personal estate of a deceased person belongs to the court of the country where the deceased was domiciled at his death. This is why if you don't have a will and a trust set up and in place, right? And if something happens, your family is arguing, they're trying to figure out who gets what, blah, 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 but they have to comply to the court, right? They have to comply to the court. I just spoke with a brother yesterday, 2 days ago, and he said that that's what happened with his mom's estate. He had the cousin that had nothing to do with it, the cousin fighting, the state was fighting, the lawyers in there in the courtroom trying to fight over his mom's property. They ain't got nothing to do with it. But because she didn't have her will and everything set up, now this is what's going on. He's like, oh, I wish I'd have talked to you weeks ago. Well, yeah, I know, brother. A lot of people don't understand how important it is to have yourself situated in these, type of positions, because anything can happen. It's crazy. It says where the deceased was domiciled at his death, the personal estate, they are sitting over there trying to go over the property rights and who has rights and arguing it in the court and so on and so forth, because it is tied into the state.
Kate Ions of Testacy and Inte Stacy belong to the judge of the domicile. It is the right and duty of that judge to constitute the personal representative of the deceased.
Brother, it's crazy.
To the court of the domicile belongs the interpretation and construction of the will of the testator.
Period.
To determine who are the next of kin or heirs of the personal estate of the testator is the prerogative of the judge of the domicile. In short, the court of the domicile is the forum concurs
so
as to
serious,
which
guys.
The legatees under the
I
will
know
of
it's
the
a little
testator
boring, but
or
please
the
listen.
PAR 76 ties entitled to the distribution of the estate of an INTE estate are required to resort. Moreover, the English court will FOIO a judgment obtained in the country in which the testator or alleged testator had his last domicile as to the testamentary character of a document, and its validity as of real arcodicu, with respect not only to the forms of execution, but also to every circumstance on which the validity of a will may depend. Westlake, Priv. Int. L2D ed. 74. And see also the succeeding sections of the same book. But as directly in point upon the statement above in the text, see Wharton, Conflow. Of L. 570, Jarman on L8, Volume LPP. 2. 4, Williams on Executors, Volume I. P 866, Foot. Priv. Int. Jur. pp. 188, 184. Savigny holds that the personal capacity of a testator in respect to his legue relations is to be determined by the concurrence of the lex domicilii, both at the time of the execution and the time of the death, and therefore, if a will be invalid, for want of testamentary.
So, real quick, Savigny holds the personal capacity of testator, right? In respect to his legal relations, not lawful, but legal. Check that out. Its legal relations is to be determined by the concurrence of the leges domicilium. So both at the time of the execution, so if a person is executionized, no, they're property, and they're property of the state, right? State property. So now they have rulership and control. So now if I were to come and take a whole indigenous town, and we just want to start arresting people, we created this martial law. We want to start arresting people and create, the domiciles that they possess, right? Once you have been convicted of a crime, or if they decide to make you convicted, you may be persecuted by hanging or death or whatever, cause that they want to put upon you, right? When this happens, they will take over your property. Don't you guys get it? Just like with a drug dealer, right? A drug dealer, they get caught, right? When they get caught, everything belongs to them, everything seized, every vehicle, every home. I don't care if the wife might have bought this home, it's all in her name, in his name, but you guys are together. So now everything's got to go, no matter what. They take control over it, because now you have been taken under the state, because you are a property. Now you're state property. That's why you have to bring yourself out of these people's system. You can't be a part of that, right? It's important to let them know they can't rule over you. You're a natural spirited being. You have a soul. You're connected kinetically to this earth. You are from the soil. So how can they tell you, how to act, what to do, policing me, enforcing policies, a policy enforcer? The only actual law is, a sheriff or marshal, right? A police officer actually doesn't have any type of authority over you when it comes to the law, maybe in a legal sense, operating out of commercial law. If you're driving and using a driver's license, and you have tied yourself to the state with this driver's license, so you put yourself into commerce. So now these policy enforcers, they have ruling over you, because see, they enforce the policies of the corporation. So when you're not tied to that, there's a little difference, because if you pulling me over, bro, I got a fee schedule. You feel me? Brother, I got a fee schedule. I suggest you go about your business. You don't want me to attack your bond officer, right? You don't want me to have to attack you because you have accosted me, taking time while I'm traveling. I'm not driving, right? Because I'm not a commercial operator. I'm traveling, minding my own personal business, and I have the right to be on the road just like anybody else. So don't bother me. And if you are bothering me, because I am a person that operates in the private, I'm going to let you know, officer, everything has a schedule fee attached to it. If you touch me, there's a fee. If you wasted my time, there's a fee. If you want to try to make me take some type of testing, a breath analyzer, you're asking for my breath out of my body that has a value. There's a connection of association to that. All of my bodily fluids belong to me. So if you're requesting that, sure, I'll give it to you, but you don't have to pay me. You want to see the fee schedule before you start asking all these things, officer? I mean, I can't let you know. Come on now. There's a way to operate in this system that they got set up to make you fail. Let's go.
Capacity according to either law, it can have no effect, but he holds that capacity with respect to physical qualities e.g., age, is ruled by the law of the domicile at the time of execution. System, etc. 377, Guthrie's Trans, p. 282, Barr holds that the law of the last domicile rules generally, but that a testament which is bad from the beginning cannot be made good merely by a subsequent change of domicile. 108, Gillespie's Trans, pp. 464, 465. See Asser et Riviere, Droit int. Priv. No. Mentary Papers, Continental jurists generally, applying the maxim loco non regit actum hold that a will is valid if executed according to the formal requirements of the place of execution but this rule is said to be merely facultative and not imperative.
We're about to move on, guys. I'm going to show you guys something else real quick before we get into this next book. We're going to look at this real quick. I showed you guys this before, so I want to make sure, because we're going to be getting into the Puritans, I want you guys to get the information on descendants and the ancient planters, right? Descendants in the order of the descendants and the ancient planters, right? Man, I got to read, but I'm going to read this small. The term ancient planter is applied to those persons who arrived in Virginia prior to June 1616. They remained for a period of 3 years and paid their passage. They paid to be there. Hey, can we, get here and, stay, get over here and see what's going on? We want to see, we heard about this good old Virginia. So they paid, right? They received the first patents of land. Listen, they received the first patents of land in the New World from the Virginia Company of London. Now, how can you get the first patents in the world when this land was already occupied? And, they had kings and queens, they had governance, everything was occupied. So there was some type of dissension of friendship that was created, right? With the friendship that was created and allowing these people to come and plan and, do a little farming and be able to cultivate, take things back to their land, so on and so forth. That was allowed at one time, right? They were allowed to get, a little space here and so on and so forth. It's authorized by Governor Sir Thomas Dale in 1618 for their personal adventure, right? So the Order of the Descendants of the Ancient Planters is an incorporated nonprofit society whose purpose is to honor and perpetuate the memory of the ancient planters. It is to promote historical and genealogical research. It is to inspire patriotism, right? And to enhance fellowship amongst those of similar interests. Oh, what is the similar interest, right? The interest would be to bring others over. Hey, let's start cultivating this land. This land over here ain't nothing. We going over here bringing stuff back all the time. We could just go there and stay there. Shit, let's just move all about, stay where we want to, start planting, start bringing more people. Sure, we'll create the woman's mission, right? Remember the woman's mission, they would bring 200 or more people over, setting up the reservations. Now so they can set the reservation up, get appointed as a chief of the land, because now they'll have guardianship over the land. All this going into the law of domicile that was allowed by the indigenous at first, because they were, we had so much space. We're loving people. We're kind people. We're a little too giving sometimes, a little too caring sometimes, right? So when doing this, allowing these people to have the space, they just kept cultivating areas, moving in, and then it's like, whoa, hold on, y'all doing too much. By this time, they were overwhelmed, right, with people. They were overwhelmed with agents, the ones that they had pulled into secrecy, starting their masonry and their organizations upon the cultivation of the nativity they created from the Siberians and the other nations that they brought in, when they were setting up the reservations, when they were setting up the plantations, when they were homesteading, taking over the land, also by bringing in the ones to actually plant the black seed in the womb of the indigenous woman, therefore stealing her actual soil on the land and property, right? Right? Everything we've been reading and talking about for months since last year, like this ain't new to us, right? But you guys can get the story. It says, and to enhance the fellowship among those of similar interest. Those are the only ones that have interest to them to keep on doing the same thing. The Order of Descendants of the Planters, of the Ancient Planters, was founded on October the 13th of 1991 in Raleigh, North Carolina. Membership is limited to descendants of the aforesaid Ancient Planters. Shit, it sounds like they need to be on our list, don't it? It sounds like these particular people, right? When we think about the Ancient Planters that were founded, right? You can't be ancient unless you come from the ancient land, unless you're a part of this soil and land, right? So how dare you say that you came and you created these plots of land on soil that did not belong to you? They may need to catch a suit real quick, right? I'm gonna keep that in mind. But let's get on to this next bit of information here. We're gonna go over when it comes to history of the Puritans. I love the preface. It gives a lot of information in one. Let's go. Starting there.
A.L. Cross Preface. This volume brings the history of the sufferings of the Puritans down to its period.
All them black-ass natives,
for though the Protestant dissenters have since complained of several difficulties and discouragements, yet most of the penal laws have been suspended. The prosecutions of the spiritual courts have been considerably restrained by the kind position of the civil powers, and liberty of conscience enjoyed without the hazard of fines, imprisonments, and other terrors of this world. The times now in review were stormy and boisterous, upon the death of King Charles I. The Constitution was dissolved. The men at the helm had no legal authority to change the government into a commonwealth. The protectorship of Cromwell was a usurpation, because grafted only on the military power, and so were all the misshapen forms into which the administration was cast till the restoration of the king. In order to pass a right judgment upon these extraordinary revolutions, the temper and circumstances of the nation are to be duly considered, for those actions which in some circumstances are highly criminal, may in a different situation of affairs become necessary. The parties engaged in the civil wars were yet living, and their resentments against each other so much inflamed, as to cut off all hopes of a reconciliation. Each dreaded the other's success, well knowing they must fall a sacrifice to those who should prevail. All present views of the king's recovering his other's throne were defeated at the Battle of Worcester, the loyalists being then entirely broken and dispersed, so that if some such extraordinary genius as Cromwell's had not undertaken to steer the nation through the storm, it had not been possible to hold. Asterisk, the reader will observe he had the period here referred to as the passing the Act of Toleration, with which M.R. Neil's fourth Tolame Conc. Lades. That the additions to the original work, B.J. notes, and supplements in this edition, have necessarily extended it to a fifth volume, which comprehends the Aylher's two last chapters, the papers that form the appendix to each of his volumes, and other papers. Edit 2. The government together till Providence should open a way for restoring the Constitution, and settling it on its legal basis. The various forms of government, if they deserve that name, which the officers of the army introduced after the death of Cromwell, made the nation sick of they carrot frenzies, and turned their eyes towards their banished sovereign, whose restoration after all could not be accomplished without great prudence on one part, and the most artful discioiolatlon on the other. Fe Presbyterians, like weak politicians, surrendered at discretion, and parted with their power on no other security than the royal word, for which they have been sufficiently reproached, though I am of opinion, that if the king had been brought in by a treaty, the succeeding parliament would
have set it aside.
On the other band, nothing can be more notorious than the deep hypocrisy of General Monk, and the solemn assurances given by the bishops and other loyalists, and even by the king himself, of burying all past offences under the foundation of the Restoration, but when they were lifted into the saddle, the haste he made to shew how little they meant by their prophylaxis, exceeded the rules of decency as well as honor.
Peace,
Nothing would satisfy, till their adversaries were disarmed, and in a manner deprived of the protection of the government, the terms of conformity were made narrower and more exceptionable than before the civil wars, the penal laws were rigorously executed, and new ones framed almost every sessions of Parliament for several successive years. The nonconformist ministers were banished 5 miles from all the corporations in England, and their people sold for sums of money to carry on the king's unlawful pleasures, and to bribe the nation into popery and slavery, till the House of Commons, awakened at last with a sense of the threatening danger, grew intractable, and was therefore dissolved. His M.St., having in vain attempted several other representatives of the people, determined time before his death to change the constitution, and govern by his sovereign will and pleasure, that the mischiefs which could not be brought upon the nation by consent of Parliament, might be introduced under the wing of the prerogative, but the Roman Catholics, not satisfied with the slow proceedings of a disguised protest, and, or apprehending that the discontents of the people and his own love of ease might induce him some time or other to change measures, resolved to have a prince of their own religion, and more sanguine principles on the throne, which hastened the crisis of the nation, and brought forward that glorious revolution of King
William
and Queen Mary, which began a final period to owe their projects. The nature of my design does not admit of a large and particular relation of all the civil transactions of these times, but only of such as may give light to the affairs of religio too, and I could have wished that the memory of both had been entirely blotted out of the records of time, if the animosities of the several parties, and their unchristian principles, had been buried with them, but as the remembering them may be a warning to posterity, it ought to give no offense one o any denomination of Christians in the present age, who are no eves answerable for the conduct of their ancestors, nor can otherwise share in a censure of it, than as they maintain the same principles, and imitate the same unchristian behavior. At the end of each year I have added the characters of the principal nonconformist ministers as they died, partly from the historians of those times, but chiefly from the writings of the late Reverend Dr. Calamy, whose integrity, moderation, and industry deserve a peculiar commendation. My design was to preserve the memory of the Reverend Assembly of Divines at Westminster, as well as the little army of confessors, who afterwards suffered so deeply in the cause of nonconformity. In passing a judgment on the several parties in church and state, I have carefully distinguished between those who went into all the arbitrary measures of the court, in such as stood firm by the Protestant religion and the liberties of their country, for it must be allowed, that in the reign of King Charles II, there were even among the clergy some of the worst as well as best of men, as will appear to a demonstration in the course of this history, but I declare it, sire, no greater stress may be laid upon facts PR characters than the quality of the vouchers in the margin will support. Where these have been differently related, I have relied on the best authorities and sometimes reported on both sides, leaving the reader to choose for himself, for if facts are larely represented, the historian is discharged. I am not so vain as to imagine this history free from errors, but if any mistakes of consequence are made to appear, they shall be acknowledged with thankfulness to those who shall point them out in a civil and friendly manner, and as I aim at nothing but truth, I see no reason to engage in a warm defense of any parties of Christians who pass before us in review, but leave their conduct to the censure of the world. Some few remarks of my own are here and there interspersed, which the reader will receive according as he apprehends them to follow from the premises, but I flatter myself, that providing he has carefully perused the several volumes of this history, he will agree with me in the following conclusions. First, that uniformity of sentiments in religion is not to be attained among Christians, nor will a comprehension within an establishment be of service to the cause of truth and liberty without a toleration of all other dudefile subjects. Wise and good men, after their most diligent searches after troth, have seen things in a different light, which is not to be avoided as long as they have liberty to judge for themselves. If Christ had appointed an infallible judge upon earth, or men were to be determined by an implicit faith in their superiors, there would be an end of such differences, but all the engines of human policy that have been set at work to obtain it have hitherto failed of success. Subscriptions, and a variety of oaths and other tests, have occasioned great mischiefs to the church. By these means men of weak morals and ambitious views have been raised to the highest preferments, while others of stricter virtue and superior talents have been neglected and laid aside, and power has been lodged in the hands of those who have used it in an unchristian manner, to force men to an agreement in sounds and outward appearances, contrary to the true conviction and sense of their minds, and thus a lasting reproach has been brought on the Christian name, and on the genuine principles of a Protestant church. To daily all parties of Christians, when in power, have been guilty of persecution for conscience sake. The annals of the church are a most melancholy demonstration of this truth. Let the reader call to mind the bloody proceedings of the popish bishops in Queen Mary's reign, and the account that has been given of the Star Chamber and High Commission Court in later times. What numbers of useful ministers have been sequestered, imprisoned, and their families reduced to poverty and disgrace, for refusing to wear a white surplice, or to comply with a few indifferent ceremonies. What havoc did the Presbyterians make
Y'all
with
get a
their
little tired.
covenant
We finna get to the last book.
uniformity, their jure divino discipline, and the rigid prohibition of reading the old service book. And though the Independents had a better notion of the rights of conscience, how defective was their instrument of government under Cromwell? How arbitrary the proceedings of T-Fire triers? How narrow their list of fundamentals? And how severe their restraints of the press? And though the rigorous proceedings of the Puritans of this S-E did by no means rival those of the prelates before and after the civil wars, yet they are so many species of persecution, and not to be justified even by the confusion of the times in which they were acted.
Let's get on to this land. Since we're talking about the land, let's talk about the land. Let's talk about the regulations that were governing the leasing of the restricted allotted Indian lands for mining purposes. It says right here that it is not applicable to the 5 civilized tribes or the Osage Nation. Interesting, huh? Let's go.
/2 P. AK regulations governing the leasing of restricted allotted Indian lands for mining purposes, not applicable to the 5 civilized tribes or Osage Nation. 4
The
P.
Osage Nation.
AI. 3A provision in the Act of March 3, 1909, 385 Stat. 781, 783, reads, that all lands allotted to Indians in Severalty, except allotments made to members of the 5 civilized tribes and Osage Indians in Oklahoma, may by said allottee be leased for mining purposes for any term of years as may be deemed advisable by the Secretary of the Interior, and the Secretary of the Interior is hereby authorized to perform any and all
acts. Keep it in mind, they're talking about
such
y'all land, right? Who else land they talking about? It says it's not applicable to the 5 civilized tribes or the Osage Nation. These are the nations that they had set up on the reservations, reserving their lands, right? So now they're going into the national lands, and they're saying what they're going to be doing with your land from your ancestors. This is what's going on. 1909, March 3rd. Listen up.
Rules and regulations as may be necessary for the purpose of carrying the provisions of this paragraph into full force and effect. 1. To carry this provision
Gold
of law
rush,
into
silver
effect, the
rush,
following
oil rush,
regulations are
water rush,
prescribed.
mineral
Ms. The
rush.
term officer in
The
charge
fuck?
herein refers
All
to the
of it.
superintendent or other officer of the Indian service or of the government who may have jurisdiction over the allotments involved.
How they got jurisdiction?
Allotments of lands are regarded as made when
How?
approved by the Secretary of the Interior, and trust patents have issued. 2.
Trust
No lease,
patents.
assignment
Trust
thereof,
patents.
or interest therein will be approved to any employee or employees of the United States government, whether connected with the Indian service or otherwise, and no employee of the Interior Department shall be permitted to acquire any interest in such leases by ownership of stock in corporations having leases or in any other manner.
Mm-hmm.
3. At such times and in such manner as he may deem appropriate, the officer in charge shall publish notices that oil and gas leases on specific tracts, each of which shall be in a compact
Oil,
body,
gas.
will be offered
Listen,
to the highest
there's so much
responsible
gas
bidder
here.
for a bonus consideration, in addition to stipulated royalties. The
The
successful bidder
royalties.
must deposit with the officer in
Listen.
charge on the day of sale a certified check or bank draft on a
Uh-huh.
solvent bank in an amount equal to 20% of the bid American Samoa, a guarantee of good faith. Balance of bonus shall be paid and lease
Guarantee
in
of good
completed
faith.
form
These
shall be
bitches.
filed within 30 days after the lease is forwarded to the lessee by the officer in charge for execution. If the successful bidder fails to complete the lease or pay the full consideration within said 380 days, or if the lease is disapproved through no fault of the lessor or the Interior Department, the amount deposited will be forfeited for the use and benefit of the Indian allottee, in the discretion of the Secretary of the
I can't
Interior.
stand these people.
The right is reserved by the Secretary of the Interior to reject any and all bids and to disapprove and reject any lease made on an accepted bid, and should any bid be rejected after deposit is made by bidder, the deposit shall be immediately returned. Madame 8951. 4. The officer in charge shall execute leases on behalf of incompetent and minor allottees. 5.
Incompetent
Leases
and
for
minor
minerals other than oil and
allottees. Who's incompetent? When you're what, feeble-minded? When you're labeled what, black? If you say, yeah, I'm black, you run around, I'm black, I'm black, I'm black and I'm proud, I'm black and I'm proud. Yeah. When you running your ass around talking about you black and you proud, when you running around talking about, yeah, I'm a minority, you know, they labeled us as a minority, right? Because what? That means you're not fundamentally correct, or feeble-minded person cannot think as an adult. So they are a minor, they're a minority. A person that can't think or see clearly, if they don't have the fundamental in their mind to have pure light and thought. Damn, it's beautiful outside, y'all. I gotta go outside in a second on this balcony. That sun like beaming right now. The when it's dang, I got distracted. But when they are using you for, I don't even know what I was thinking. Man, that sun literally just took my whole thought, y'all. I don't know how it's looking where y'all at, but today is like the most beautiful day I've seen in a while. It's got to be purified, crystal clean air, like literally right now. I don't know how long it's gonna last, but I'm sure finna get about a minute or two when they keep reading. But guys, keeping this in mind, you know, all these things that they have taken, basically, I know I was saying about these lands, you know, stealing the lands, taking the lands, taking the mineral rights and the oil rights and all of these things, putting them under what they just claim the land of. And specifically, you see it said not the 5 tribes, not the Osage, because remember, they already had them set up in a place. But let's go.
Gas shall be negotiated with the Indian allottee whose lands are sought to be leased after permission.
Gas rights. That's what I was gonna say. Thank you. The gas rights. You know, all these land places. Now think about it. Remember, I told y'all about Sarah Rector. Remember Sarah Rector, the first richest little white indigenous girl, millionaire at 11 years of age. Just like so many of them Oklahomians, those people, it was over 400 different families that had oil back then. She was just the richest and the quickest. Her family just had the largest amount of oil, the quickest. And that's why she was a millionaire at 11, right? So keep that in mind.
Due has first been obtained from the officer in charge, and, with the papers required, shall be filed with the officer in charge within 30 days from and after the date of execution, provided that no such lease on lands of incompetent and minor allottees shall be made until competitive bids have been invited therefor by advertising for at least 2 weeks in 2 or more papers of general circulation in the vicinity. But if a minor is interested with competent adults in inherited lands, and such adults agree respecting a lease, the officer in charge may sign for the minor without advertising. The minor's age and date of birth must be shown whenever possible. The successful bidder for lands advertised shall pay the cost of advertisement. 6. If the applicant for a lease is a corporation, it shall file evidence of authority of its officers to execute papers, and with its first application it shall also file 1. A certified copy of its articles of incorporation, and, if foreign to the state in which the lands are located, evidence showing conformance with the corporation laws thereof. 2. Lists of officers and stockholders with post office addresses and number of shares
Dang, I
held
can't
by
even tell
each.
you. Y'all hearing this?
3.
Are
A
y'all
sworn
listening? I had
statement
to
of
come
the
back just
proper
so y'all
officer
can make sure
showing
y'all heard that.
A. The total number of shares of the capital stock actually issued and the amount of cash
Let's hear
paid
that
into the
again.
if the applicant for the minor's age and date of birth must be shown whenever possible. The successful bidder for lands advertised shall pay the cost of advertisement. 6. If the applicant for a lease is a corporation, it shall file evidence of authority of its officers to execute papers, and with its first application it shall also file 1. A certified copy of its articles of incorporation, and, if foreign to the state in which the lands are located, evidence showing conformance with the corporation laws thereof. 2. Lists of officers and stockholders with post office addresses and number of shares held by each. 3. A sworn statement of the proper officer showing A. The total number of shares of the capital stock actually issued and the amount of cash paid into the treasury on each share sold, or, if paid in property, the kind, quantity, and value of the same paid per share. 6. Of the stock sold, how much remains unpaid, and subject to assessment. C. The amount of cash the company has in its treasury and elsewhere, and from what sources it was received. D. The property, exclusive of cash, owned by the company and its value. E. The total indebtedness of the company and the nature of its obligations. 7 statements of changes in officers and stockholders shall be furnished by a corporation lessee to the officer in charge on January 1st of each year, and at such other times as may be requested. Affidavits may also be required of individual stockholders at any time, setting forth in what corporations or with what persons, firms, or associations such individual stockholders are interested in mining leases of restricted Indian lands within the state, and whether they hold such interests for themselves or in trust. 8. Except to prevent loss or waste, leases of undivided, inherited lands will be approved only when accompanied by proof that the lessors are the only heirs of the deceased allottee. Heirship must be established in accordance with the Act of June 25, 1910, 36 Stat 855, and the regulations prescribed thereunder. If the heirs have already been so determined, the officer in charge, when forwarding the lease, shall refer to the date and file number of Indian office letter notifying him of such determination. If the heirs include a life den cit, unt. tenant, the lease must be accompanied by an agreement between such tenant and the remainder men, providing for the division of the rents and royalties, subject to approval of the Secretary of the Interior. If the heirs to an allotment are undetermined or cannot be located, and it appears necessary to lease the land to prevent loss or waste, the officer in charge will report the facts to the Commissioner of Indian Affairs and ask for instructions. 9. Lessees shall furnish with each lease a bond, Form 5-154B, with 2 or more personal sureties, or with an acceptable company authorized to act as sole surety. Such bond shall be in amount as follows: for less than 80 acres, $1,000, for 80 acres and less than 120 acres, $1,500, for 120 acres and not more than 160 acres, $2,000, and for each additional 40 acres or part thereof above 160 acres, $500, provided that a lessee may file one bond, Form 5-154F, in the sum of $15,000, covering all leases of a particular class on any one reservation to which he is or may become a party. The right is reserved at any time, before or after approval of a lease, to increase the amount of a bond above the sum named.
Right, brother. I had to go out just to get some of that sun. Literally, it's like no jacket, nothing. It feels like 100 degrees almost standing in. It's so freaking pure. It's so beautiful. I don't know if anybody else went out. Y'all really need to take a second if you're inside and you're not going out to at least go out and get some of this fresh air. Literally, it is pure and clean. I could see it as soon as I looked out there. I'm looking like, oh, whoa. You could tell by the sky just how it looks. At least I can with my discernment. So I suggest y'all get out there and get a couple of breaths of fresh air in your system, in your lungs, absorb some of that sun real quick. Shit, you can put me on pause, come back to this later. I don't even give a damn. Like literally go take some of that in, y'all. I'm so serious. I'm not just saying it. All right, let's go.
In any case where the secretary...
Wait. I was listening to what it was saying. Are you guys listening to everything this thing is telling me? It's telling you about the trust. I keep telling you. It told y'all about what they was putting it into and how they did it. And like, y'all hearing this? Like, I hope y'all really paying attention. Like, the chat kind of low, but y'all get the message. I know they'll come in later and see it. So y'all make sure y'all paying attention. Get it right now.
Of the Interior deems it proper to do so. 10. The officer in charge may, either before or after approval of a lease, call for any additional information desired to carry out these regulations. If a lessee shall fail to furnish the papers necessary to put his lease and bond in proper form for consideration, the officer in charge shall forward such lease for disapproval. 11. Oil and gas mining leases shall be made for a period of 10 years from the date of approval by the Secretary of the Interior and as much longer thereafter as oil, gas, casing head gas, or any one of them, is produced in paying quantities, or the gas royalties for wells capable of producing gas in paying quantities, but not utilized are paid or as much longer thereafter as lessee is engaged in completing the drilling of a well commenced during the 10-year term, provided such drilling is prosecuted to completion of the well with due diligence.
That excuse about the oil. We fight for oil. We fight for oil. Remember, they was raising the gas prices, all of that. The gas right here, guys. America has the largest amount of oil and gas. Like literally playing games with your mind, but that's a whole nother story. Let's go.
And if such drilling operations result in the finding of any one of the substances covered by the lease, then the lease shall remain in force as long as such substance is produced in paying quantities, provided, should lessee be unable to market the production from the leased land, he may, with the consent of the Secretary of the Interior, discontinue the operation of the producing wells thereon, and the lease shall remain in force notwithstanding such cessation of operations, provided further, that if, while the lease is being held by production alone, the well, or wells thereon shall cease to produce for any cause, lessee, with the consent of the Secretary of the Interior, shall have the period of 120 days from the stopping of production within which, at his election, to commence operations for the drilling of another well, deepen an existing well or wells, or otherwise to attempt to restore the production of such existing well or wells, and if such work is so commenced and prosecuted with reasonable diligence, and production of any such substance results therefrom, the lease shall remain in force as long thereafter as such substance is produced in paying quantities. Leases for other minerals shall be for a period of 15 years. 12. No individual, corporation, partnership, company, or association shall hold under leases for mining purposes restricted Indian lands in any one state in excess of the following areas, exclusive of holdings in the 5 civilized tribes and the Osage Nation, AZ, on deposits of the nature of lodes or veins, containing ores of gold, silver, copper, lead, zinc, or other useful metals,
All those
not
little
more
minerals,
than 640 acres. 6. For beds of placer gold, lands thereafter as such substance is produced in paying quantities. Leases for other minerals shall be for a period of 15 years. 12. No individual, corporation, partnership, company, or association shall hold under leases for mining purposes restricted Indian lands in any one state in excess of the following areas, exclusive of holdings in the 5 civilized tribes and the Osage Nation, AZ, on deposits of the nature of lodes or veins, containing ores of gold, silver, copper, lead, zinc, or other useful metals, not more than 640 acres. 6. for beds of placer gold, gypsum, asphaltum, phosphate, iron, ores, or other useful minerals
All
other than
kind of
coal,
useful minerals,
oil,
huh?
and gas,
Oil,
not more than
gas, what I told y'all.
960 acres.
That's
C.
just one area.
For
Come on.
coal, oil, or gas, not more than 4,800 acres, except that in the state of Oklahoma there is no limitation to the number of acres any lessee may acquire, by lease or assignment, for oil or gas mining purposes. Rents and royalties 13. All rents, royalties, and other payment due under leases which have been or may be approved by the Secretary of the Interior shall be paid to
You
the
hear this
officer
shit?
in charge, or to such other person as may be designated by the Secretary of the Interior, for the benefit of the.
Because, see, they got to put them in charge so they can have the wardship over you and the guardianship. Guarding your funds, guarding your trust funds from your ancestors, guarding what belongs to you, usurping and making theatrics and fake ass scenes like the Wild West show where they portrayed and showed you these people that were supposed to be indigenous Indian people, but they were actually Native Americans. They can't call them Indians because they're not Indians, but they're Native Americans. Parading them around the world, creating these scenes. These are people. So now they can use these people as a front, having an act portrayed, right? And then now a further part of the theatrics are putting these people on the reservations and the plantations, right? Having all these parties coming in, the black and the white natives, because the Africans that came through Canada, through Old England, Seneca County, Seneca Township, which, the township was right there in Central Park, New York. When they came through there, they were participating as well, doing the same thing. The Quakers, pioneersmen, frontiersmen, right? They were doing the same thing. So we had the black natives and we had the white natives that were coming in, invading us on both ends. Both were planting their dark black seed into the belly of the indigenous and taking over her land, her property. That was coming down the line from the whole entire heresy, right? Everything had to go to the woman because she is the one that carries the line, within her seed. She carries the line, the matriarchal line that is stored in the womb of the indigenous woman, right? She is kinetically tied to the soil because why? Every egg cell in her sac that she was born with, mind you, when she was born at birth, every egg cell is in her sac. So as she grows and she produces and nourishes the heresy of the bloodline of the kinetically connected kings and queens of the land, right? They had to come and impede upon that to put themselves in the line and take over the land, doing the usurping of everything, right? Y'all get it? That's y'all see what's going on, right? Listen, then they taking all your rights, all your mineral rights, everything. They don't want to give you the proper credit you deserve, which is the line of gold, silver, minerals, oil, water, even the water shit, even the water arts. There's rights to all this stuff. And see, they have it in under these conservatorships, under the trust, as I've been telling you guys about forever. They have it under conservatorship, right? And they have it under the trust. And now they're using that to fund everyone else. Someone comes from another place. Hey, we want to help build something in America. Okay, great. Here, we'll help you with a corporation. We'll give you some government funding. And then here, you go ahead and get started. Just make sure that you're building the neighborhood. You have to have an article of incorporation, a certificate of participation, and your company registration so that you are now able to form a trinity of servitude for the community. Sure, I'll do that, government. So then now they set up the facility. You're supposed to go in there and give your percentage of thought to them so that they can, grow in the community because they're here to so-called build it up, right? But what they're doing is usurping, right? They're taking your commodities. When you come in and you complete that application, as soon as you complete that application, now you are giving them a negotiable instrument they can now trade on the stock market because you created a binding agreement, right? Because your application is what? It's a bond. It's a it's a bond. It's a bill of lading that now you are saying that you're investing in this company. So they're trading you on the stock market like you're a slave because you literally signed yourself over. Your soul signed yourself over to the devil, him damn self. Believe it or not. Let's go. Here we go.
Lands in any one state. C. For coal, rents and royalties 13. All rents, royalties, and other payment due under leases which have been or may be approved by the Secretary of the Interior shall be paid to the officer in charge, or to such other person as may be designated by the Secretary of the Interior, for the benefit of the various lessors.
Right.
No credit will be given any lessee for rents or
Crazy.
royalties paid direct to the lessors or their representatives. 14 lessee shall pay on each oil and gas lease annually in
They
advance,
shall pay. The hell
commencing
you
from the
paying on
date of
somebody
approval
else
by
shit?
the Secretary of the
How do you
Interior,
people sound?
and continuing until lessee shall have drilled the producing well. Royalties as follows: 15 cents per acre per annum for the first and second years, 80 cents per acre per annum for the third and fourth years, 75 cents per acre per annum for the fifth year, and $1 per acre per annum for each succeeding year during the term of the lease. Such payments shall be made until the royalties on production exceed the advance royalty, provided that should the producing well or wells on the leased land cease to produce during the fixed term of the lease, then at the next succeeding advance royalty paying day the lessee shall resume the payment of advance royalty. Advance annual royalties at the rates above prescribed shall also be paid on leases for minerals other than oil.
I'm a record keeper, guys. I'm gonna say something. Something just popped in my head. I was just thinking, like, damn, it's only like 30 people in here. I take so much time to put into these bills, and I be wanting people to really get this information. It's crazy how when I came in these communities, I was just building on people's channels, putting information out, sharing with them, bringing new information, even though they would never give me credit or say, "Oh, thanks, sister so. Oh, you put me on, sister so." They'll just go and make a build about what information I shared on their panel, never give me any kind of fortitude, not wanting to bring attention to the person that likes to bring and shed light to the information. This type of video, right, should be shared out by every indigenous, Aboriginal, Indian, conscious, Black, whatever you think you are. You all should be sharing this shit out. You feel me? You know why y'all should be sharing it out? Because it needs to be said. Everyone needs to know what they did to us, how they did it, the way that they did it, the things that they used to do it, the things they put in place, using a paper genocide against us, using theatrics, a whole fake ass system that they created, and people falling for the shit and still fall for it right now, even though that shit is done. Even though, Washington is like over, that shit is over. If anybody seen my TikTok video yesterday, y'all see, I showed all of it. Washington literally with the chains on it, like that shit was sold like 3 years ago. They sold Washington, D.C. because they was out of here. They had to go. Their gig was up. Like literally. We need to be sharing this information out so people really know what's going on. People need to understand what these people have been doing to us so that we know our rights and we know who we are and who we're standing in, so on and so forth. We got to let people know. Peace travel. We got to let people know what has been going on. And we have to show them that we have the proof. We're not just saying this. We're not people, oh, y'all just saying it, that. No, dummy. Take your time and read, study, research, get some information from the person that do put it out there, share it, let people know what's going on so they'll know that they've been playing with us. You feel me? I'm so tired of this community. It's so sad. I was building on people's channels or whatever. They never support me. Never say, oh, y'all make sure y'all go watch Sister Soul. She be, giving some good information. They don't want to build your channel up because they just want to make sure they building theirs. It's about the popularity. Oh shoot, I don't want to put them out there and support them too much because then people be like, damn, they got some info and shit. They'll be paying more attention to them than me. Well, damn. Is that what's going on? Because that's what I'm saying. I'm seeing a lot of hatred, jealousy, no support. People I've built with, they don't come over here never to jump on the panel. They don't never want to do, I'll still go here and there, jump in their chat and shit, but all that jumping on the panel, I don't even care. To share nothing over there. If people that have been watching me on y'all channels haven't found my channel to get this information, I don't even know what to say for you. It's really sad. They already know that YouTube blocks my channel. They already know that they be unsubscribing people from my channel because I talk about it all the time. The people the people that have been here talk about it all the time. They had subscribed 2 or 3 times. They know that they are what they call shadow. They shadow ban my channel. You know what I'm saying? Like, damn, give me some kind of support, y'all. This is about us. It's not about a me thing. It's not about, oh, I'm trying to one y'all up because I know more than y'all. Shit, I do know more than y'all. I study more. It's evident, like from the shit y'all talk about. half the things y'all talking about, y'all learned from me, and then y'all act like y'all studied and researched it, but all y'all did was get the information and put y'all little twist on it, and then start talking about the shit like y'all studied something or really care to show y'all people, enlighten y'all people. You know, it's really sad. Oh, I want to do this, and we need to build our community, or we need to do this and that. Well, what are y'all doing? How y'all building the community? You can't even build with the people around you, even the people that build with you, the people that have been sharing things with you, people that have been, building on your channels, things of that nature. People, it's like, man, it's sick. I really get annoyed with it, but I'm learning to conserve my energy. I don't like when people, are selfish and disgusting with themselves, and they don't really care about our people. It's all about them, their popularity. They need certain attention and stuff. People need attention. I'm not an attention seeker. Shit, I get that anywhere. Shit, I can go out the damn door. I'm gonna get some attention. That's real talk. No joke. Like what? So it's not a big deal for me to get some damn attention. So it seems like that's what's going on. Y'all not trying to help our people, and I'm getting pissed off about it. I get tired of it. I get tired of y'all not supporting the the real people in this community that's really putting the information out. Like literally, I went to people's page just to see if they shared that, and they don't even be sharing my stuff out. Empress Holber, she shared a couple of things. She used to share it. I don't know what happened. Since when I had that little fallout with Negas, I ain't heard from her no more. And like it's not a big deal for me. Much love to her, whatever. But like I don't even understand why people get problems. They don't call you, let you know what. I don't even know what the problem is, or if it's a problem. We speak in the chat, but it's like, okay, I ain't heard from you, sis. I'm just waiting to see. But okay, I still ain't heard. It's not a big deal. You feel me? I've done all I could with sharing and loving on people and stuff. So I just don't understand it. Same thing with Ad Power. Come do an interview with me, sister. So okay, I'm like, oh, what you want to talk about, brother? Oh, it's just what? It's gonna be what? Some little ghetto word on the street shit? I don't do that, brother. I don't play around my platform. You're not finna try to put me on the spot, play games with me, all that old disrespectful shit y'all love to do over there. Because I don't really want to curse your ass out. Like really, none of y'all. Like I love everybody in this community as long as you can respect me, which I don't get much of that. But when I do get it, the shit is crazy. I didn't even mean to go here with this conversation. We're going to get back into this, but that just really crossed my mind. Like, damn, that should be like really disgusting. Like, I don't understand. I ain't did nothing but show love since I've been in this community. Jump up on their panels, share shit, share documents, information, pictures, talk about things, that they're not familiar with so they can be aware of, because that's what I want everybody to do. Be aware, come to your knowing, your inner soul, your inner self. Know what's going on with you so that you're able to prosper things in your life, your mind, your body, your spirit, and doing that for who? Your circumference of people that are in your area, your family, your loved ones, maybe even some friends. Sometimes people be on these slavery jobs for a while and they've developed friendships with people, the people you care about. You want to help them grow, and you know what I'm saying? But I've done it for like 2 years plus on this community. It's been nothing but hate. Backstabbing, hate, people try to, put me down, this and that, or whatever. They'll be rude, disrespectful when I flip on their ass and put them in their space. Then now I'm, sister, so mean. This is like some of the weirdest damn characters. All you characters, y'all playing a role or something. I don't even be getting the shit. But yeah, let's get back to this, y'all. That just came in my head. I was not trying to go there, but I definitely felt the need to. So let's go.
And guess. Payments of advance royalty shall be a credit on stipulated royalties for the year for which the payment of advance royalty is made, and the sums of money so paid shall not be refunded to the
crazy
lessee because of any subsequent surrender or cancellation of the lease, nor shall the lessee be relieved from the obligation to pay said advance royalty annually when it becomes due by reason of any subsequent surrender or cancellation of the lease.
Always supporting.
The advance royalty for the first year shall be paid to the officer in charge at the time of filing the lease, and the amount so paid shall be and become the property of the lessor if the lease be disapproved because of the lessee's failure to meet the requirements of
I want to make sure y'all heard
the law or these regulations, or because of any other fault or defect chargeable to the lessee. The advance lessee because of any subsequent surrender or cancellation of advance annual royalties at the rates above prescribed shall also be paid on leases for minerals other than oil and gas. Payments of advance royalty shall be a credit on stipulated royalties for the year for which the payment of advance royalty is made, and the sums of money so paid shall not be refunded to the lessee because of any subsequent surrender or cancellation of the lease, nor shall the lessee be relieved from the obligation to pay said advance royalty annually when it becomes due by reason of any subsequent surrender or cancellation of the lease. The advance royalty for the first year shall be paid to the officer in charge at the time of filing the lease, and the amount so paid shall be and become the property of the lessor if the lease be disapproved because of the lessee's failure to meet the requirements of the law or these regulations, or because of any other fault or defect chargeable to the lessee. 15. The minimum rate of royalty on oil shall be 12.14% of the gross proceeds of all crude oil extracted from the leased premises, payment to be made at the time of sale or removal of the oil, and in no event shall such royalty be paid on the basis of less than the posted market price for oil of like quality, grade, and gravity in the particular oil field of which the lease is a
I don't
part
know
the
what I
day the
did to
oil
the
is
screen,
run
guys. I'm finna come back in
to the
on another
pipeline or
screen.
into permanent storage. The consent secretary of the Interior store the oil and defer settlement royalties until such pipeline connections are secured or until such other facilities for the marketing of the production from have the option to purchase the
Okay.
highest
This other screen was acting crazy. Oh my God, I'm gonna have to kick this out. Give me a second. And still end up with the screen that's acting crazy. Hold on, guys. 1 second. All right, guys. Let me get it. Goodness gracious. See? Always having some type of weird ass issue. That was so crazy. I don't even want to get into what was going on, but yeah, here we go. We're back on it. Okay. I don't know where it was messing up at. I'm gonna just go back one paragraph.
In time of war or other public emergency, any of the executive departments of the United States government shall have the option to purchase at the highest posted market price on the date of sale all or any part of the oil produced under any lease. 16. The royalty on gas, whether it shall be gas from which the casing head gasoline
Appreciate
has
you,
been
bro.
extracted or otherwise, shall be 12.14% of the value thereof in the field where produced, provided that where wells produce both oil and gas or oil and gas and water to such an extent that the gas is unfit for ordinary domestic purposes, but is used temporarily in connection with drilling and pumping operations on adjacent or nearby tracts, the lessee shall pay royalty at the rate of 12.14% of the gross proceeds of the sale of gas from such wells. Failure on the part of the lessee to use a gas-producing well which cannot profitably be utilized at the
Now,
rate
this
herein.
is back, like, let's say over 100 years ago. So think about the price of all the royalties on certain lands that are in trust for Indians, right? Indians, the true Indians, not the Native Americans, but the lands that are in trust for the Indians now. And we're not, like, getting our stuff. Don't y'all think that's crazy?
Named shall not work a forfeiture of the lease so far as it relates to mining oil, but if the lessee desires to retain gas-producing privileges, he shall pay a rental of $100 per annum in advance, calculated from the date of the discovery of gas on each gas-producing well, the gas from which is not marketed nor utilized other than for operations under the lease. If the leased premises produce gas in excess of lessee's requirements for the development and operation of said premises, then lessor may use sufficient gas free of charge for all stoves and inside lights in the principal dwelling house on said land by making his own connection with the well or wells thereon, the use of such gas to be at lessor's risk at all times. On casing head gas used or sold for the manufacture of casing head gasoline, the rate of royalty shall be 12.14% of the value of the casing head gas, which value shall be determined and computed on the basis and in the manner provided in the regulations governing the utilization of casing head gas produced from oil wells on restricted Indian lands. In cases where gas produced and sold has a value for drip gasoline, casing head gasoline content, and as dry gas from which the casing head gasoline has been extracted, then the royalties above provided shall be paid on all such values. YYISE, evidence of discovery of gas wells and the beginning of utilization must be furnished promptly in the form of a sworn statement. Payments of annual gas royalties shall be made within 25 days from the date such royalties become due, other royalty payments to be made monthly on or before the 25th day of the month succeeding. 54706-25-2. That for which such payment is to be made, supported by sworn statements. The capacity of wells shall be ascertained, under the direction of the Secretary of the Interior, when necessary under the terms of the lease to determine the amount of royalty to be collected. Except in cases of emergency, which shall not exceed 10 days, not more than 20% of the capacity of any gas well shall be utilized. 17. The royalty on coal shall not be less than 10 cents per ton of 2,000 pounds on mine run, or coal as it is taken from the mines, including what is commonly called slag. 18. The royalty on asphaltum shall be not less.
Guys, I'm gonna step away for a second. I'm gonna be in the chat though. I'm gonna take my phone because I'm definitely, brother just made me think. I'm like, them little few minutes ain't do nothing. I'm steady looking outside. I'm about to go on the balcony, but I will be in the chat. Let's go.
Than 10 cents per ton of 2,000 pounds on crude asphalt or 60 cents per ton on refined asphalt. 19. For gold, silver, copper, lead, zinc, and tungsten, the lessee shall pay quarterly a royalty of not less than 10% to be computed on the gross value of the ores as shown by reduction returns copyright after deducting freight and treatment charges. 20. For substances other than gold, silver, copper, lead, zinc, tungsten, coal, asphaltum and allied substances, oil, and gas, the lessee shall pay quarterly a royalty of not less than 10% of the value at the nearest shipping point. 21. With the consent of the officer in charge, lessees may make arrangements with the purchasers of oil for the payment of the royalties to the officer in charge by such purchasers, but such arrangement, if made, shall not operate to relieve a lessee from responsibility should the purchaser fail or refuse to pay royalties when Do. Where lessees avail themselves of this privilege, division orders permitting the pipeline companies or other purchasers of the oil to withhold the royalty interest shall be executed and forwarded to the officer in charge for approval before wells are brought in, as pipeline companies are not permitted to accept or run oil from leased Indian lands until after the approval of a division order showing that the lessee has a lease regularly approved and in effect. The right is reserved to cancel a division order at any time or require the pipeline company to discontinue to run the oil of any lessee who fails to operate the lease properly or otherwise violates the provisions of the lease or of these regulations. 22 Royalty payments on leases other than oil and gas shall be made monthly, on or before the 25th day of the month succeeding that for which such payment is to be made. 23 A sworn report of the lessee shall accompany each royalty remittance, covering all operations, whether there has been production or not, except that where division orders have been approved and the royalty paid by the pipeline company or other purchaser of oil, lessees need not make monthly reports direct. All leases upon which there is no production or upon which dry holes have been drilled may be included in one report. 24 Separate quarterly reports for each lease, whether or not oil royalty is paid by the pipeline company or other purchaser, shall be submitted by the lessee to the officer in charge within 15 days. After March 31st, June 30th, September 30th, and December 31st of each year, upon prescribed forms, showing manner of operation, total production, and all receipts during the quarter from any operations under the lease for the benefit of the lessor or the lessee, or both, giving amount of each payment, name of person making same, and nature of the operations from which the money paid was derived. Sworn reports of gas wells shall be made both when discovered and when utilized. Stipulations 25. The lessee under any lease heretofore approved may, by stipulation, with the consent of the lessor and the approval of the Secretary of the Interior, make such approved lease subject to all the terms, conditions, and provisions contained in these regulations and in the lease form authorized and adopted in pursuance thereof. Form 5-154I shall be used for this purpose. Assignments 26. A. Leases hereafter approved, or any interest therein, may be assigned or transferred only with the approval of the Secretary of the Interior, and to procure such approval the assignee must be qualified to hold such lease under existing rules and regulations, and shall furnish a satisfactory bond for the faithful performance of the covenants and conditions thereof. 6. No lease or any interest therein or the use of such lease shall be assigned, sublet, or transferred, directly or indirectly, by working or drilling contract, or otherwise, without the consent of the Secretary of the Interior. C. Assignments of leases and stipulations modifying the terms of existing leases shall be filed with the officer in charge within 30 days after the date of execution. Cancellations 27. A lease will be cancelled by the Secretary of the Interior for good cause upon application of the lessor or lessee, or if at any time the Secretary is satisfied that the provisions of the lease or of any regulations heretofore or hereafter prescribed have been violated. When the lessee applies for cancellation, he must, before the same will be considered, pay a surrender fee of $1 and all royalties and rents due to the date of completion of such application, surrender all parts of the lease actually delivered to him, and furnish a duly recorded release of the acreage covered by the application if the lease thereon has been recorded, provided that where the application is made by an assignee to whom no copy of the lease was delivered, he will be required to surrender only his copy of the assignment. If the lease is owned in undivided interests by more than one person, firm, or corporation, all shall join in the application for cancellation. All required fees and papers must be at least in the mail on or before the date upon which rents and royalties become due, in order for the lessee and his surety to be relieved from liability for the payment thereof. No part of any advance royalties or annual rentals shall be refunded to the lessee, nor shall he be relieved from his obligation to pay royalties and rentals annually when due by reason of any subsequent surrender or cancellation of the lease. Upon cancellation of a lease, the lessor shall be entitled to take immediate possession of the land. Operations 28. Lessees will be required to carry out and observe the regulations now or hereafter in force governing oil and gas operations on restricted Indian lands. Operations will not be permitted under any lease requiring approval of the Secretary of the Interior until the approved lease has been delivered. If there has been a contest respecting a lease or leases, the approved, disapproved, or cancelled parts thereof will be held in the office of the officer in charge for 5 days after promulgation by him, by mailing or delivery of the department's decision, and will not be delivered if within that period a motion for review or reconsideration be filed until such motion is passed upon by the department. 29. Lessee shall commence the drilling of a test well on the land covered by the lease within 1 year from the approval thereof by the Secretary of the Interior, or, in lieu thereof, beginning 1 year from such approval, pay the officer in charge in advance an annual rental of $1 per acre, such payments to continue throughout the 10-year term, or until the drilling of said test well is commenced, or the lease is surrendered in the manner provided therein. The completion of a well or wells producing oil, gas, or casing head gas in paying quantities shall terminate lessee's obligation to pay rentals thereunder during the producing life of such well or wells, provided that should the producing well or wells on the land cease to produce during the fixed term of the lease, or a test well come in dry during said period, then at the next succeeding annual rental paying day, lessee shall resume the payments of rental, unless prior thereto he has commenced the drilling of another test, or has surrendered the lease. The lessee may be required by the Secretary of the Interior, or by such officer as he may designate for the purpose, to drill and operate wells to offset paying wells on adjoining tracts and within 300 feet of the dividing line, except that where the well or wells to be offset are paying gas wells, the lessee shall be relieved of his obligation to drill upon payment of a sum equivalent to the gas royalty stipulated for in the lease, and for such purpose the open flow capacity and the use to which the offset well is devoted shall be the criterion to determine the lessee's royalty obligation. 30. Lessees shall agree to allow the lessors and their agents or any authorized representative of the Interior Department to enter, from time to time, upon and into all parts of the leased premises for the purposes of inspection, and shall further agree to keep a full and correct account of all operations and make reports thereof, as herein required, and their books and records showing manner of operations and persons interested shall be open at all times for examination of such officers of the department as shall be instructed in writing by the Secretary of the Interior to make such examination. 31. Oil shall not be sold to a pipeline company until division order is filed as hereinbefore provided. Should the lessee desire to sell oil or remove it from the leased premises in any other manner, such sale or removal shall not be made until authorized by the officer in charge. Lessee or his representative shall actually be present when oil taken under division orders is run by pipeline companies, and lessee shall be responsible for the correct measurement and report of oil so run. Otherwise, the approval of division order may be revoked. Land from which restrictions have been or may be removed. 32. All leases of any description whatever executed by an allottee on land from all of which the restrictions against alienation had been removed before such execution may be executed without any provision for reference to or supervision by the Secretary of the Interior or any official of the Department of the Interior, and the officer in charge shall refuse to accept for consideration any lease covering land from all of which restrictions had been removed before such execution. 33. All leases executed before the removal of restrictions against alienation on land from all of which restrictions against alienation shall be removed after such execution, if such leases contain specific provision for approval by the Secretary of the Interior, whether now filed with the Department or presented for consideration hereafter, will be considered and acted upon by this Department as heretofore. 34. Oil and gas leases heretofore approved and leases for other minerals now or hereafter in force on land from all of which restrictions against alienation have been or shall be removed, even if such leases contain provisions authorizing supervision by this Department, shall, after such removal of restrictions against alienation, be operated entirely free from such supervision, and the authority and power delegated to the Secretary of the Interior in said leases shall cease, and all payments required to be made to the officer in charge shall thereafter be made to lessor or the then owner of said land, and changes in regulations thereafter made by the Secretary of the Interior applicable to oil and gas leases shall not apply to such leased land from which said restrictions are removed. In the event restrictions are removed from a part of the land included in any lease to which this section applies, the entire lease shall continue subject to the supervision of the Secretary of the Interior, and all royalties thereunder shall be paid to the officer in charge until such time as the lessor and lessee shall furnish the Secretary of the Interior satisfactory information that adequate arrangements have been made to account for the oil, gas, or mineral upon the restricted land separately from that upon the unrestricted. Thereafter the restricted land only shall be subject to the supervision of the Secretary of the Interior, provided that the unrestricted portion shall be relieved from such supervision as in the lease or regulations provided. 35. All oil and gas leases hereafter executed shall contain the following relinquishment of supervision clause and terms operative after such relinquishment. Should the Secretary of the Interior, at any time during the life of this asterisk instrument, relinquish supervision hereof as to all or part of the acreage covered hereby, such relinquishment shall not bind lessee until lessor shall have given lessee 30 days written notice of such relinquishment, accompanied by a certificate of the officer in charge, officially evidencing such relinquishment. Until said requirements are fulfilled, lessee may continue to make all payments due hereunder, whether royalties, advance royalties, or rentals, to the officer in charge, who, for these purposes, shall be deemed the lawful agent of lessor and his successors entitled to receive said payments and distribute same. After notice and proof of relinquishment have been received by lessee, as herein provided, this lease shall be subject to the following further conditions. A. All royalties, advance royalties, and rentals for deferred drilling operations thereafter accruing shall be paid in the following manner. Royalties shall not be paid to lessor or his successors in title, or to a trustee appointed under the provisions of paragraph 9 hereof, at the time, in the manner, and subject to the conditions herein before set out respecting the payment of such royalties to the officer in charge. Advance royalties and rentals for deferred drilling operations shall be paid directly to lessor or his successors in title, or to said trustee, as the case may be, or, at lessee's election, the same may be Masleek or Gayavetio asterisk toll LNEE cakes EED EELB dark or 82 pounds 05 EE. Wo VPSLE for deposit to the credit of lessor, his successors in title, or said trustee, which bank or its successors is hereby made the lawful agent of lessor or his successors in title, or said trustee, to receive and distribute said payments, and said bank or its successors shall continue as such agent. During the period that advance royalties and rentals are payable hereunder, regardless of any change in the ownership of said land or of said advance royalties or rentals. All payments called for in this paragraph may be made by lessee's check or bank draft, and the mailing of same, postage prepaid, on or before the due date of the particular installment represented by such check or draft, shall prevent a forfeiture under the provisions of paragraph 2 hereof. 0. After such relinquishment of supervision this lease may be assigned, in whole or in part, without the approval of the Secretary of the Interior and without the consent of lessor, the assignee, or assignees, to enjoy all the rights and privileges herein before specifically granted assignees hereof. C. If at the time supervision hereof is relinquished lessee shall have made all payments then due hereunder and shall have fully performed all obligations on its part to be performed up to the time of such relinquishment, then the bond given to secure the performance hereof, on file in the Indian Office, shall be of no further force or effect. D. After such relinquishment this instrument shall no longer be subject to the supervisory regulations of the Secretary of the Interior, and the power of the Secretary of the Interior to prescribe regulations of this character shall not be transferred to nor vested in lessor, and all the acts herein provided to be done and performed by the lessee with the consent or on the approval of the Secretary may be done or performed by the lessee without such consent or approval and without limitation or condition. E. Should such relinquishment affect part of the acreage hereof only, then lessee may continue to drill and operate the land covered hereby as an entirety, provided lessee shall pay to the officer in charge for the benefit of lessor such proportion of all royalties, advance royalties, and rentals due hereunder as the acreage retained under the supervision of the Secretary of the Interior bears to the entire acreage of the lease, the remainder of such royalties, advance royalties, and rentals to be paid directly to lessor or his successors in title, or
You hear these people? Okay, I want to show y'all this. These is the plots of land. I just want y'all to see. I can't really read it. As y'all see, it's very faded. I can make out some of the names, but it's very, very faded. They are like the original records, the glow records. So it shows the plots of land. I just want y'all to see that the plots of land here. This is a township north of Bosline Range in let's see, it's surveyed by this particular person, and it gives all the plots of land that were entitled in the allodial titles. So these are all the acres, how many acres they got, so on and so forth. But the names are listed here. Unfortunately, like I said, you can barely like read it. It's so faded, and then it looks like it was written in pencil, maybe. So it was very light. And the lead has definitely faded. Some it may even just be ink, and the ink's just so faded because you can see it's like you can see a few things you can make out, but it's kind of hard to show it. Let me see. I want to show one more thing about the states real quick. The land promise for these damn Cherokees, the traders. They won't let me go into that book though. It's blocked on here. I got like 25 more minutes. What can I show y'all real quick? Letters patent of King Henry the 7th. Y'all want to see that real quick? I was actually looking for something on banking. I wanted to show y'all some banking stuff. Maybe I should go there instead. Go back. Go here. Instead. Hold on, guys. I didn't have this organized. I just popped in here this morning with a couple of things I want to go over. Maybe I can get some of these windows closed. Oh, I wonder if I should show y'all that. I don't know. I have to say that for private. It's a little too much. But I did show you guys some court documents the other day. Tony was like, "Oh, don't take that off." But I mean, something on trust. No, I'm not gonna talk to y'all about trust because y'all don't get trust. Y'all do not get trust. Let's see. Let's do some of the American spirit in letters real quick. 25 minutes. We could browse through some stuff on this particular document. Let me check in. Okay. Make it a little bigger. Pageant of America, the American Spirit in Letters. This talks about a few things. 18th century literature, revolution, era of Washington and Jefferson, and all that nonsense. Knickerbocker Group, 19th century poets, writers, all these writers, they had to write themselves into history. Literature of the new America, they had to start creating literature for a new created America, a new world order, a very trends of thought, modern American letters. Maybe we could just get into some of the letters, see what they were talking about, because we can browse through that for like 20 minutes before I get up out of here. Note on the pictures on the index, which just kind of shows all the pictures they have here, so on and so forth. So this, dang, I wish I could have found what I wanted to show y'all, because I could have did that for 20 minutes. Maybe while this is reading, I could grab it. I'll look around real quick. Okay, let me see. I want to go to the spirit letters. Let's do the spirit letters. I said 290 something. Let's see. All these fake ass letters. We got to write our history. You come some damn place. You just get there, and then you're going to start writing history. How the hell you writing history on some damn place you just got to? Make it make sense. So would somebody make that make sense? Because it damn sure don't make sense to me. All right. Here we go. Perfect. Let's start with the confessionals. Let's start with this. This is a great page to start with.
We need not trace as in fiction the ancestry of realism in the new poetry.
Fiction.
All such study of the relation of the
Damn.
present to the
Oh my
past
God.
brings us in the end to a form frequent in, have quickened our intellectual life, but the indifference to the past of criticism has its dangers.
Listen to this.
The critic guided by the past, equipped by knowledge and principles, a word hateful to the iconoclasts, hardly exists as in England and France. Our magazines tell the story. In our discussions we no longer care or have time for the old critical essay. A form frequent enough in English periodicals. Criticism has become a brilliant game, a business of reviewing, a contest of clever comment. We need not trace as in fiction the ancestry of realism in the new poetry.
Fiction.
All such study of
Of
the relation of
realism
the present to the past
in the
brings
new
us in the
poetry.
end to
Listen.
the name of Whitman. His assertion that he would be the poet of the future has not been taken seriously by his people of these states, but there are few modern poets who owe nothing to him.
These people crazy.
Since
They are
1900 there has
literally
been
nuts.
sentimental
Do you hear me?
poetry in the manner
They
of the
nuts.
New England school,
Anybody that
but it
believes
is a
them
whisper
nuts too.
compared with the
I'm
new
telling you now.
voices. Perhaps
Insane.
Edwin Markham, Bliss Carman, Richard Hovey, and lesser men than Whitman hastened the change. In the poetry of William Vaughan Moody there is protest. Startling at any rate is the complete revolution in respect to subject and form. The strength of the new movement in American poetry lies in its sincere devotion to actual life. Sarah Teasdale declares bravely that the vigorous spirit of America is producing the best poetry which is now being written in English. Such a statement is strong enough, but it may be true. In the poetry appear to be more fervor and literary conscience than in the fiction. For the central fact about all this poetry is its interest in everyday life. Modern poetry is curious about life, and it is equally curious about the forms of art which shall reveal this life most truly. Hence in the eccentrics we encounter ridiculous subjects and tortured meters, but in the better poets an amazing verisimilitude. Life itself, as we know it today, is in their poetry. This passion for truth takes innumerable forms. In Edwin Arlington Robinson we meet the Puritan in his later struggle with his inheritance. After searing self-analysis, he sets forth an intellectual adjustment of the modern man afflicted by such a legacy. Robert Frost shows in more external ways the New England community and scenery. As our consciousness widens, other racial influences appear, as in the realism of Edgar Lee Masters and Carl Sandburg. The latter is an apotheosis of the immigrant. The new times, wrote Whitman, the new people, the new vistas need a tongue accordingly, yes, and what is more they will have such a tongue. I shall attempt no catalogue of the subjects of this new tongue, or of its accents. Masters, in the simplest language, repeats the life histories of village folk buried in a western churchyard. Vatchell. Lindsay describes in onomatopoetic rhymes a political parade, a Negro dance, or California wails. Ezra Pound's silhouettes faces in the subway. There are the imagists, H. D. and John Gould Fletcher. In various combinations of occult sound and strange theme, we have not merely lyricists, but rhapsodists, expressionists, impressionists, vorticists,
Sorcery.
and heaven help us cerebralists.
Sound like sorcery to me.
Possibly the leaders, though not the sponsors, of this new poetry, are those poets mentioned in the preceding paragraph and Amy Lowell. Her recent defenses of imagism and of the new thought, coupled with her own sound performance, help to give it a hearing. As to the future, who will hazard a guess? The camp followers build their little fires, as ever when new enterprises stir the human mind. The passers-by smile, and talk of the return to convention or the old-fashioned romance. This alone we know, that never before has literature in America been so distinctive or so intellectually alive. Winston Churchill, 1871. Winston Churchill is the novelist of the patriotic, energetic American. In Richard Carville, 1899, The Crisis, 1901, Collision, 1906, or The Inside of the Cup, 1913, one may enjoy the picturesque romance of American history. Or the patriotic reader may resolve to perfect still further his American democracy. For Churchill, active in New Hampshire politics, transfers to his novels his moral earnestness. He is clearly influenced by Theodore Roosevelt, whose own performance as a man of letters the next generation will judge. Churchill's books lack subtlety and show no great stylistic power, but represent excellently the democratic and romantic aspirations of a vast number of Americans. 772 I. Brown Brothers. 771 Underwood and Underwood. Jack London, 1876 to 1916. Far more typical of the early years of the century's literature was Jack London, who bade us prepare for the kingdom of the brute, and who, single-handed, almost throttled sentimentalism. London tasted the dregs of life, and performed incredible sacrifices to enter the University of California. He returned disillusioned, but with literary ambitions, to a life in the Klondike, before the mast, and of wandering over the earth. In the war between Russia and Japan he served as a newspaper correspondent. His life, with its melodramatic struggles and physical exaltation, was the real source of his superabundant fiction about hurricanes, fistfights, wrecks, diseases, and terrors of the night. His ideals in literature were to be assimilated to the point of absurdity by writers such as Rex Beach and Zane Grey. The spirit of his novels, influenced first by Bret Harte and Kipling, London sought stronger teachers in Marx, Nietzsche, and the Russian realists. London's romantic strain carried him beyond these into a nightmare world of supermen and strange heroic countries. He exaggerates, like some primitive writer of early races. Even the dogs in his aurora-lighted northern climes are like the animals of Norse gods. The Call of the Wild, 1903, or The Sea Wolf, 1904, his best novels, suggest his inexhaustible vitality, his lurid sense of the dramatic, as well as his diffuseness, and other weaknesses of style. The autobiographical books such as Martin Eden, 1909, or John Barleycorn, 1913, reveal best the man himself. 773. 774 Copyright Brown Brothers etchings of crude America. What Carol Kennicott beheld as she walked from the station at Gopher Prairie, Minnesota, the garage, the moving picture palace, the men in shirt sleeves, the linen on the lines, the salesman whom the successful Babbitt knew at his club. These acid etchings of crude, complacent America amused and chagrined us.
All these damn actors.
Aerosmith,
You see
1925,
actors.
in part a satire on medical training and the life of a physician, is still more powerful and hints that Lewis has not even yet put forth
It'd be
his
like
full
watching
strength.
a real life movie.
776 Copyright Brown Brothers Sinclair Lewis,
Fiction.
1885. In his excitement, Jack London was a little absurd. American realism was to be calmer.
Realism
4 years
put into
after London's
poetry,
death,
the
Sinclair
new
Lewis,
poetry in the
a
new
young
world,
newspaper man,
right?
wrote Main Street, 1920. In a few months the title was an idiom of current speech. Lewis knew nearly every corner of commonplace America, and he never forgot what he saw. This novel and Babbitt, 1922, were at once photography, satire, and caricature. 775 Sinclair Lewis and James Branch Cabell, courtesy O.L. Robert M. McBride and Co. Theodore Dreiser, 1871. By such pictures Hamlin Garland's realism becomes antiquated. Yet it is Theodore Dreiser who refuses to let us draw our own conclusions from sordid American life. He dwells upon it, argues about it, and probes gloomily into biological motives. Had his master, Zola, lived in our day, and in America, so he would have written, though never so clumsily. Dreiser, hopeless student of brutality and animalism, is, nevertheless, our greatest novelist of naturalism. Naturalism. His life gave him the materials for such books as Sister Carrie, 1900, Jenny Gerhardt, 1911, The Brooding Novel, The Genius, 1915, or An American Tragedy, 1926. Booth Tarkington, 1869. The propaganda in the novels of Lewis and Dreiser is
Listen,
slight compared with
propaganda
that
in the
in The
novels.
Socialist.
Pay
Upton
attention.
Sinclair, author of The Jungle, 1906, or The Brass Check, 1919. No realism could be more different from these than that of Booth Tarkington, who has moved gradually away from
Peace and love, brother.
the Rococo romance of Monsieur Beaucaire, 1900, to the wholesome studies of American life in Alice Adams, 1921, and The Midlander, 1924. Tarkington in Indiana knew the earlier Hoosiers, was the friend of Riley, and he has never lost interest in the political destinies of his state. His abandonment, after the years at Princeton, of the profession of art, symbolizes to some his failure as an unusual craftsman in fiction. 777 L. Underwood
Fiction,
and Underwood
fiction,
Stories
fiction.
of American Life. His
Fiction,
sympathetic
fiction,
interest
fiction.
in adolescence has made the Penrod stories Penrod, 1914, Penrod and
Why you
Sam,
always see sketches like
1916,
this? You never see
17,
real pictures of them with
1916,
anything.
a source of
real.
entertainment to all America.
Nothing
They have
substantial.
the likeness of Kate Douglas.
Always a sketch.
Wickens Juvenile Stories Rebecca of Sunnybrook Farm, 1903, and are, besides, briskly modern. In political stories like The Gentleman from Indiana, 1899, Tarkington shows his mastery of American backgrounds. The later novels make us wonder if he may not possess more than talent. In Alice Adams, with its daring and
They
beautiful
had a whole book of
ending,
writers.
and in The Midlander is much
They
of the
brought in all
actuality
at
of
the
Lewis and
same
the other
damn time.
realists, ennobled by
Ain't that
hopeful
something?
American virtues.
Thousands
Here
of
is
them.
Main Street in Sunlight 778 from Booth
Writing
Tarkington,
the story
and
of
Monsieur
America.
Beaucaire, 1902.
Why they
Drawing
burning
by
down your
C.
damn truth?
D. Williams. Copyright Doubleday, Page & Co. Willa Cather, 1875. Much of the same light plays about the stories of the West by Willa Cather, rendering her superior to such writers as Charles G. Norris or his wife Kathleen Norris, the brother and sister-in-law of Frank Norris. Zero Pioneers, 1913, by Miss Cather,
Pioneers.
proclaimed her interest in the changing life of the frontier. My Antonia,
She could be an
Antonia,
African. Right? What did the American Atlas tell us? That when the Africans were coming in, a lot of them were pale with light eyes, and some of them even had light hair, blonde hair, light brown hair, light eyes, right? So she could even be an African, right? A pale African, albino.
1918,
Not
is
really
her
albino, but they all come from that stock, right? That's why they have a light skin.
most powerful novel. The brilliant short stories in the collection Youth and the Bright Medusa, 1920, give promise of her art in telling a tale,
Yes, sis.
fulfilled in the
You hear
admirable
this?
picture of
Say
Western
something
life,
else.
one of ours, 1922. Miss Cather's denouements are likely to be sketchy,
PC
as in
not.
the half-symbolical study of the decadence of the West, A Lost Lady, 1923. MRS. Forrester represents, perhaps, the West, and its surrender to materialism. Miss Cather gives always an impression of reserve and strength. In The Professor S. House, 1925, she writes again, with symbolism, of the sadness of fulfillment. Zona Gale, 1874. The limitations of American life are more harassing in the novels of Zona Gale, a writer with delicate
You know she a
perceptions,
radium
and
child.
with a
Look.
style that challenges the English May Sinclair,
Look at her face.
though the latter is a far greater novelist.
Now this is
The
the
origin
time.
of her career.
Hold on. This is the time they were creating the radium, the nitrogen and radium test tube as babies, right? Look at her face. Look at her skin. Remember, if anyone in the chat, put a one in the chat if anybody remembers the way their face look in their skin. Look at her skin. You can see it. Let me go in more. She was probably needing radium. Look at her skin. You can see it all in her skin. She came up here. Yes, I'm right, because she can get all the radium she needs. They had the suppositories, the cigarettes, the beauty products. Yeah, she needed to get to America to start writing her a story so she could have a life. If she wasn't already created here. They had 6 different facilities. They had a baby incubator facility in Switzerland, Germany, Italy. Like these people, something else, right? Let's go.
her manner of writing, and something even of her character are hinted at in her comment on an early event. I secured a position by attrition. I presented myself every morning at the desk of the city editor. At the end of 2 weeks, the city editor let me write about a flower show. I have never put such emotion into anything else I have written. The emotion in Lulu. Bet, 1920, the story of the spinster drudge in the Western family, is restrained and harrowing. This and Faint Perfume, 1923, and even Sudler's study of environment, have revived her earlier novel. Birth, 1918. 781 Alice Book. Dorothy Canfield Fisher, 1879. With feel pigs strong but far less contained, and with a manner too explicit, Dorothy Canfield Fisher has written stories of New England life, such as Hillsborough People, 1915. Her later novels, The Products of Life Abroad, blend the European and American scenes. The Brimming Cup, 1921, and Rough Hewn, 1922, are studies of courtship and marriage. The later stories, Home Fires in France, 1918, The Day of Glory, 1919, Raw Material, 1923, are inferior to Hillsborough People. Edith, Newbold Jones, Wharton, 1862. This influence in modern fiction of European life upon women who have lived long abroad is distinct in Anne Sedgwick, author of Tant, 1911, and Adrian Toner, 1922. The supreme instance. 781 Underwood and Underwood, however, is Edith Newbold Jones Wharton, who depicts the old New England in Ethan Frame, 1911, or the old Manhattan in the Age of Innocence, 1920, and Old New York, 1924, or Europe both old and new in a sun at the front, 1923. Begin. Ning in childhood MRS. Wharton has spent much time in Europe. She became early a student of languages and of the acknowledged masters of fiction. Her first book, The Greater Inclination, 1899, published in her 37th year, was the first of a series of sophisticated novels of character. MRS.
Novels of character.
Wharton was long ago the pupil of Henry
fathers.
James, but now draws essentially nothing from
The
him.
founding fathers.
She is clear, cool, distantly ironic, and in moments thrillingly intense. Untouched, like more obvious realists, by our rasping life, she yet understands us well, and no better studies of the effect of American environments on character have been written in recent years than Ethan Frome and The Age of Innocence. Margaret Deland, 1857. With The Age of Henry James, too, is associated Margaret Deland, human being battling with a great force, such as heredity or religion. 783 Copyright Brown Brothers, Joseph Hergesheimer, 1881. Of the most thorough, often a colorist.
A
The
colorist. Hold on, I should let that
Above
one play.
all,
Hold on.
whether in the earlier novels or The Bright Shawl, 9. Human being battling with a great force, such as heredity or religion. 783 Copyright Brown Brothers, Joseph Hergesheimer, 1881. Of the most thorough investigators of American backgrounds is Joseph Hergesheimer, who will collect, probably not unaided, the material for a job ahead, 1919, with the patience of a graduate student. A realist in technique,
Yeah, the real true
Hergesheimer
Walking
is
Dead.
often a colorist
Right about that.
and painter of pictures. His novels are full of scents, sounds, and hues, and are European in point of view. Nor are the colors always untouched by decadence. Witness The Three Black Pennies, 1917, or The Unpleasantly Plush Cytherea,
The Black
1922.
Pennies.
He represents our realists who find a certain beauty in the drab. Above all, whether in the earlier novels or The Bright Shawl, 1922, Hergesheimer, a theorist in the novel, is a craftsman. We can deny this no more than we can ignore his frequent bad taste. 785 From a Notograph by Alfred Stieglitz, courtesy of Hubse, Inc. 784 Courtesy of Alfred A. Knopf, Incorporated. Sherwood Anderson, 1876. Foremost among students of America who possess a marked psychological bias is Sherwood Anderson, of humble parentage and meager education, who worked 5 years as a laborer. His Weinsberg, Ohio, 1919, is a study of character in a small town. More typical of his original attack on the novel form is his Many Marriages, 1923, which strips off the upper layers of consciousness to comprehend the real egos of certain insignificant people, with startling, if sometimes futile, effects. Anderson thinks sex has hitherto received inadequate emphasis in literature. His autobiographical confessional almost restores the balance for all literature. No one can accuse him of leaving sex out of the novel. 786 courtesy of Robert M. McBride and Co. James Branch Cabell, 1879. A more cultivated artist is James Branch Cabell, a Southerner and a romantic, a lyrist in prose, one sharpened with a briar-like irony. Beyond Life,
The pain of a damn America, the
sums up his
pageant, the
philosophy of
story,
art.
the theatrics of America.
He asserts, meet humor, unscrupulous with cheapness. He occasionally, George Ade, 1866. Humor found further expression in journalism in John Kendrick Bangs, who continued to write well on into the 20th century,
writer.
and whose most genial and clever compositions were real
Civil
anticipations
War
of modern
humorist,
humor.
really. What's
The
humorous
Houseboat
about
on
it?
the Sticks, 1895, is still a delightful skit. His successors, Finley Peter Dunne, the M.R. Dooley series, 1898 and later, and George Ade, belong more precisely to our own time, particularly Ade, whose fables in slang, 1900, have sequels at this moment. An interesting and perhaps in one sense a final development of American humor is the newspaper columns of Wit and Wisdom, conducted by Bert Leston Taylor, Franklin P. Adams, F. P.A. Don Marquis, and Christopher
So
Morley.
many more.
The adult Civil War humorists would enjoy this laughter. The caricature, the observation, and the dialect are here in 20th century dress. George Edward Woodberry, 1855. But we must hasten from the humorists and from the dramatists, of whom Percy Mackaye, Augustus Thomas, and Eugene O'Neill are representative, to criticism. Here indeed since the days of E. P. Whipple's glory, no. 738, and Matthew Arnold's despair of us, is activity. Henry Van Dyke, poet and essayist, writes gentle criticism in the old manner. George E. Woodberry, no. 789, also a poet, published in 1921 his 6 volumes of collected essays. A graduate of Harvard, he was professor of English at the University of Nebraska, 1877 to 78, and of comparative literature at Columbia from 1891 to 1904. Since that date he has written much, including criticism of Lamb, Tennyson, Coleridge, Shelley, and Swinburne. We turn often to these dependable studies of books and men of letters. His Edgar Allan Poe, 1885, revised later, is one of the few excellent critical biographies written in America. Bliss Perry, a novelist and critic, carries on the tradition, and typifies the best American critical thought. 789 Alice Bowden 790 courtesy of Alfred A. Knopf, Incorporated. Henry Louis Mencken, 1880. Strikingly opposed to the old tradition is the group of writers who have sworn death in America to the conventional, the academic, the puritanical, or the crude. James Gibbons Juncker, musical and dramatic critic, with his iconoclast Sabule of dramatists, 1905, Ivory Apes and Peacocks, 1915, or the autobiographical Steeplejack, 1919.
They crazy. When you look at all this stuff, it just be so amazing, like crazy to me that people just still let these people keep doing this stuff and nobody's really doing shit about it. But let's go, guys. Peace, love, and bliss to everyone. I'm out after this.
There's seriously nothing cooler than black cowboys. Big facts. Black cowboys have always been around.
It's so true. Check this out. That was Lethal Lex. She's an amazing person and the actual founder of the BLM Utah chapter. Go check her out. Now, when a person sees a black cowboy and they think that idea doesn't make sense because all we've ever seen are white cowboys, you would be 100% factually wrong. The very first cowboys were black, beginning with the actual term. White men who worked a ranch were called cowhands. Black men who worked a ranch were called cowboy. Yes, the actual term is stooped in racism. You're seeing a John Wayne or a Clint Eastwood. What you're actually seeing is a very poor imitation of a famous black cowboy. His name was Nat Love, better known as Deadwood Dick, who was ridiculously talented in all things cowboy. From Bill Pickett, who invented the sport of bulldogging, Ass Reeves, who was the actual real Lone Ranger, Hannah July, who was so talented at taming wild horses, the U.S. Army actually hired her. There is no such thing as a cowboy as we know it without black people. Black history is American history, plain and simple. Actually hired her. There is no such thing as a cowboy as we know it without black people. Black history is American history, plain and simple.